Please, Lordship.
Yes.
I'd like to mention hearing item number 28, Lordship.
Yes.
Lordship, today I see a mistake. Generally, we have to generally go out of station, Lordship. So if this matter can come up next week on Monday, Lordship. Hearing item number 28, Lordship.
Next Monday,
Yes, Lordship.
on a prayer made on behalf of the petitioner, matter is adjourned to be listed on Monday. Huh?
Lordship, please tell me that.
Interim order passed earlier to continue till the next date of listing.
Lordship, please. Please, Your Lordship, I'd like to mention item number 3 and 4. Here state is yet to file affidavit, so kindly grant me 3 weeks time.
In both the matters,
Yes, Your Lordship.
okay. On a prayer made on behalf of the state, matter is adjourned by 3 weeks. Whenever filing of affidavit in opposition.
Your Lordship, similar prayer for item number 11. State is yet to file affidavit here.
Item 11.
Please, Your Lordship.
Okay. State, no?
Lordship.
Sir, Lordship, I'd like to mention hearing item number 38.
38, yes. Yes.
Lordship, let the matter in this for 2 weeks.
After 2 weeks,
Yes, Lordship.
you're questioning the power of the Lokayukta.
Yes, Lordship.
You're for the petitioner.
Yes, Lordship.
On a prayer, yes.
I'm appearing for private respondent 5 to 9.
Hmm.
Lordship is a long pending case and there is a stay order in favor of the petitioner.
We have seen that.
So let the matter be disposed of on next week.
Why are you seeking time? Every time there is an
Lordship.
interim order which has been extended. Yes, you are correct.
Lordship, my senior is in bereavement.
Senior is in bereavement. Okay. There's a personal reason today. We'll grant, but we'll fix a date.
Lordship.
Next Tuesday. Next Tuesday. Okay. 4th. A prayer for adjournment has been made on behalf of the petitioner on citing personal grounds. Though the Learned State Council has not opposed the aforesaid prayer in principle, he has informed that there is an interim order whereby the disciplinary proceeding has been put to a halt. Mr. Para, considering the above, though the matter is adjourned, the same is directed to be listed on 4th.
Lordship, interim order may be continued.
4th. Interim order passed earlier to continue till the next date of listing. 4/6, yes. 4/6 will go for disposal.
Please, Your Lordship, I beg to mention item 10, Your Lordship. Here
Yes.
the state is yet to file counter. I may be kindly granted 3 weeks time, Your Lordship.
Item 10.
Yes, Your Lordship.
Okay, same, huh? Okay,
Your Lordship, similar prayer for item 20, Your Lordship.
20.
Here also the state is yet to file, Your Lordship.
23 matter, okay. 2 weeks.
Much obliged. Your Lordship.
Yes, Your Lordship, I beg to mention item number 23.
23 years.
And for the respondent, this matter may be listed after 1 week.
Why? Some difficulty today.
11, June.
Now, why are you seeking adjournment?
Lordship,
Why are you seeking adjournment?
Lordship, I have some personal difficulties. Hello?
The Learned State Council has prayed for a slight accommodation. But this is the 19th matter,
Yes.
slight accommodation for the para. However, though the adjournment is granted, considering that this writ petition is of the year 2019, list for hearing on 4th,
11 June. Tuesday.
next Tuesday.
After 1 week.
Yes, 4th, next Tuesday.
11, I think.
No, do it 19 matter. We are accommodating you for today, 4th. 4th, 4/6 for hearing. Yes.
Lordship. Hello.
May it please, my lord. Lordship, though I am for the petitioner, Lordship, my learned friend, who is appearing for respondents 2, 4, and 5, in item 27, Lordship, he is not keeping well today, Lordship. So
Who's not keeping well?
the counsel for the respondents 2, 4, and 5.
Okay, 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 okay.
So I'm for respondent 2, 4, and 5.
Okay, okay.
My senior has some.
Okay, we'll fix another date.
Yes, so if it can kindly be fixed on 4th, Lordship.
It is submitted that the leading counsel for respondent numbers 2, 4, and 5 is not well today. Para, as paid for, list on 4, 6. Okay,
My
4,
lord.
6.
Yes, my lord. Much obliged.
Please, your lordship, I'd like to mention item number 6. Your lordship, we are yet to file our affidavit, so can we grant us 3 weeks time?
You're for the government,
For the respondent 5.
private respondent. Private respondent. No, you're for the private
Yes,
respondent.
Lordship.
State has filed
Respondent
affidavit.
Lordship,
You have filed.
lordship.
Okay. On a prayer made on behalf of the respondent number 5, matter is adjourned by 2 weeks,
3 weeks.
3 weeks to enable filing of affidavit in operation. Okay.
Lordship, I beg to make sure item 12.
12, yes.
Lordship, I pray that I will be granted 2 weeks time to file my affidavit in opposition.
You're for R3,
Respondent number 3, Lordship.
yes. State has filed affidavit, otherwise,
No, lordship, yet to receive instructions.
okay, then we'll grant time to both of you.
Lordship.
The learned state council as well as the learned council for the respondent 3, pray for and are granted 3 weeks time to obtain instructions / file affidavit in opposition. 3 weeks, okay. You're for the petitioner?
Yes, Lord.
Lordship. So, Lordship, I'd like to mention item
5 years,
on behalf of Appeal Assembly.
yes. What is your prayer?
Your Lordship is here to file affidavit in opposition if 2 weeks may be granted.
Okay, we granted 3 weeks time. State you're for R5.
Respondent
State has filed affidavit. Okay, R5, huh? 3 weeks. Okay,
Lordship, there's an interim.
Sarah, interim order passed earlier to continue till the next.
So, lordship, I beg to mention item number 7.
Yes,
Lordship, we are yet to file a written reply, so kind grant us 4 weeks time.
for rejoinder affidavit. 4 weeks for what purpose? Reply affidavit.
Yes, yes, reply.
That is for a rejoinder. Okay, you have filed your affidavit, madam. State?
Yes, Your Lordship.
Okay. On a prayer made on behalf of the petitioner, matter is adjourned by 2 weeks,
4 weeks.
not 4 weeks, 3 weeks to file rejoinder affidavit against the affidavit in opposition of the state. Okay.
May it please your lordship, I beg to mention item number 21.
21 years.
I'm the petitioner.
Yes. Yes, what is your prayer?
2 weeks time may be given for reply of
The
government.
affidavit. Okay,
Yes.
you have filed the affidavit. Okay, it's same, huh? Rejoinder affidavit. 3 weeks then. Is there any interim order? Is there any interim order? No.
No, lordship. Bless you, lordship.
For motion, item number 31.
Lordship, I have a very limited prayer.
Yes,
Filing
sir.
this instance.
Yes, under the rules, is a minor son entitled for family pension if in case the mother also expires. No, guardian has come before the court. Guardian is moving on behalf of the minor grandson. The father of the minor passed away. He was a government servant. Mother was receiving family pension. Mother had also in the meantime passed away. So the claim is now made on behalf of the son of the government employee through his grandfather. His son entitled for family pension under the rules.
Lordship, under Rule 54 of the CCS pension rules. CCS pension rule is applicable in the state of London.
The child is major, the guardian will have to, not the petitioner, your lordship, but as
No,
a minor, your
there
lordship.
is one small issue, which is a very technical issue, that the name of the minor son was
Yes.
not
Yes,
put in
included.
the papers, so
Yes,
he's not getting. You take instructions, we'll issue notice, and then we'll also make an observation that pendency of the case will not be a bar for consideration of the representation.
My lord.
Or we so in learned counsel for the petitioner. The petition has been moved in representative capacity for the grandson with a claim for family pension. It is projected that the father of the claimant was a government servant and who had passed away, and thereafter the mother of the claimant was receiving the family pension. However, unfortunately, the mother had also passed away.
My lord.
Though, according to the petitioner, the minor son is entitled to family pension, only because of some technical issue, the family pension has not been released to the claimant through the petitioner. In this regard, the petitioner has also submitted representation,
My lord.
which is pending. That notice be issued, returnable by 6 weeks,
Lordship, if it can be 2 weeks, lordship.
returnable by 4 weeks.
My lord.
4 weeks. Madam, for all,
For 1, 2, 3, 5, and 6.
4 and 4.
4 is 4, I'm not.
Who is AG? AG, anyone? Standing counsel? You'll be for AG? Okay. This is state council 1, 2, 3, 4, 3, 5, and 6. And so, standing council,
My lord.
AG. Extra copies
My lord.
by tomorrow.
My lord. My lord.
The pendency of this case shall not be a bar for consideration and disposal of the representation.
My lord.
Try to redress this issue if he is otherwise entitled to finish it. For family pension, one did not come to the court. If otherwise there is no problem. Okay.
Deeply obliged.
Item number 32.
May it please your lordship.
Yes.
Your lordship, the
Who is for the state? See,
petitioner.
there is a provision in 37 that till the last date of nomination, you can make some changes. See, 36 otherwise will not cover his case. 3 conditions will not cover. 37 may cover his case because he claims to be a voter in the Constituent Assembly.
My lord.
His only name is not there in the ULB. So you take instructions, we can have this on Monday.
Your lordship, the small obstruction is the 4th March notification, which my lord has already.
The 4th March will not come into your, 37 is clear.
Yes, your lordship.
37 is clear, and you need not pray for quashing 4th March. Irrespective of 4th March, your name can still be included.
Yes, your
37
lordship.
powers are wide enough.
So if that observation can be given by your lordship, the representation dated 28th of May, May 2024, your lordship.
Both are similar.
Yes, your lordship. 32 and
33.
33.
Say a separate ULB constituency,
Yes, your lordship.
separate wards.
Separate wards. The petitioner in item number 32 is a voter in the ward number 11 and is also an intending candidate. And the item number 33 is a voter is a resident of ward number 10, and she is also an intending candidate, your lordship.
we'll issue a short notice. You get back when? Wednesday next?
Wednesday
Today's what?
next
Today's
Is
nomination is from 7 to 11.
7 to 11, Your Lordship.
worship next Monday.
Yes, third will dispose this of.
Third, Your Lordship, whether that will be a little too far because the office will have to go through a procedure to again include their name. In the meantime, they also have to file nomination, Your Lordship.
So when do you?
Nomination will be from 7 on.
7. No, if there's a
Yes.
court order, you'll be allowed to contest. What is the difficulty?
Lordship, can we take it up on Friday, take a chance on Friday?
Friday, he not have any.
At least an instruction to see whether it will be possible to dispose of on Monday or not.
No, we'll have it on Monday. Don't worry.
We will fix on Monday.
Yeah. We will not issue notice also. We'll have it at the instructions.
My
right
lord.
Before motion.
Your Lordship, my lord.
Both the petitioners in the instant writ petitions are have claimed to be voters in the 35 number assembly constituency
My lord.
and are residents respectively of ward numbers 11 and 10
Yes, Your Lordship.
under the Kohima Municipal Board.
Zineboto, Your Lordship.
Zeneboto Municipal Board,
Zineboto Municipal Town Council,
Zeneboto Municipal Town Council,
my lord.
and are intending to contest
Candidates, yes, my lord.
in the ensuing elections for the state council.
My lord.
Full stop. It is claimed that the names of the petitioners were duly given to be inserted in the voters list
My lord.
through the proper procedure.
Yes, Your
Full
Lordship.
stop. However, due to some negligence of the authority, their names have not been included,
My lord.
as a result of which, it is claimed that their valuable rights would be infringed. Full stop. The learned counsel for the petitioner has also drawn the attention of this court to sections 36 and 37 of the Arunachal Pradesh Municipal Act
No,
2013.
Your Lordship, the
Sorry,
Nagaland,
Nagaland,
yes,
the Nagaland Municipal Act 2013.
2023.
2023.
Yes.
Full stop. Under section 37, names can be included till the before the last date of filing of nominations.
My lord.
Full stop. Para. Considering the urgency, the Sri London State Council is directed to obtain instructions for invoking the powers of section 37 and consider the representation accordingly. Full stop.
Well.
Para. List for consideration, list for motion again on Monday next, on which date an endeavor would be made to dispose of the writ petitions based on the instructions that may be received. Full stop. Para. To facilitate receipt of the instructions, the learned counsel for the petitioner would furnish extra copies of the writ petition to the learned state council during the
Monday.
course of the day.
Your Lordship.
Yes.
Right, Your Lordship.
Both.
For admission, item number 1.
The pleadings are completed, Lordship, in this case. If this matter may be taken up for admission hearing next week, Lordship.
What do you say? What is the subject matter?
It's about recognition of the institute, Lordship. The petitioners, they took their course from an institute and they have approached the authorities, Lordship, by filing
What is
their
the name of the institute?
Indian Institute for Paramedical Counsel, Lordship. It's based in Kohima, Lordship.
Next. Okay. The learned counsel for the parties jointly submit that the pleadings are complete and the matter can be taken up for disposal at the admission stage. Sarah, list for admission hearing on Tuesday next. Day after tomorrow. On
6th,
on
June.
6th June.
Item number 2.
Please, Your Lordship. Lordship, the petitioner's pension is under process as of now, so I pray that it may come up after 4 weeks.
Okay. Yes? Yes. The learned counsel for the petitioner has informed this court that there are developments for redressal of the grievance of the petitioner pertaining to pension.
Yes, sir.
Para. The learned state council presents endorses the aforesaid submission for para. In view of the aforesaid development, list this case after 4 weeks.
Obliged.
For admission, item number 8.
Item 8, please.
Please, my lord.
Yes.
Lordship, it has been fixed for admission hearing, so
Correct.
we are ready.
Please.
Lordship, require of the selection process. Lordship, petitioner is challenging the appointment of the verbal respondent of three.
Who's for the aspirant number 3? You for
I
3?
am Lordship.
Okay.
Now, here the question is, she
Let
is
me
not a
complete.
landowner.
Let me complete.
Okay, then we'll hear you in detail, don't worry. So just trying to inform something. Okay, you have challenged an appointment of R3, R3,
R5,
R5 as
multitasker staff,
as
multitasker staff.
MTS. Okay.
On
In,
sick,
in,
on
whi-
sick ground.
in which department?
Zenibudi College.
In the college. Okay.
First ground worship, there is no advertisement,
No advertisement.
no process at all, lordship,
No advertisement.
no process, nothing.
Okay.
So as a background appointment, lordship.
Yes.
There is a government office number which provides for to fill up the grade 3 and grade 4 posts by inviting application
Mm.
from the indigenous and evidence of the particular district. That is office memorandum dated 4/6/2016.
Mm.
And third ground worship, there is another office memorandum issued by district government worship, that is OM dated 4/2/2005,
2005.
whereby instruction has been imposed for appointment of the relatives after availing voluntary retirement.
What is the restriction?
For appointment of relatives, kins and relatives
Means of whom?
of the government employees who avail voluntary retirement.
Availing voluntary retirement. Okay.
Lordship, at the time of filing the petition, my second claim was appointment and then ownership. Then ownership. Because the land was donated by my father in the year 1995. Yeah, of course.
Your father donated the land
Yes, Lordship.
for this college.
Lordship. Lordship. I'll
No,
come to
okay.
that, Lordship.
Yes.
And there is an agreement, Lordship, to that effect. For appointment of landowners. However, Lordship, in the year 2018, 2008,
2008.
yes, the land was purchased by the government
From whom?
from the landowners.
No, you said your father had donated the land for the college.
Yes, in the year 1985.
Yes.
However, in the year 2008, Lordship, the land was purchased by the government
From whom?
from the landowners.
From your father also.
My father and including other landowners, because the land has been donated by middle landowners, not only the father petitioner. There are many landowners.
No, that doesn't matter. But since you claim that your father had donated the land in 1985,
Yes, sir.
once you donate the land, your father donates the land, then your ownership ceases. You're no longer the owner.
There is a condition for appointment of landowners. Lordship.
No, that is okay. That's a different matter. Whether after donating the land, you or your sons get the appointment as a
Subsequently, Lordship, subsequently, the state government have taken a decision to purchase the land from the landowners. Accordingly, the land was purchased.
that means the donation will not be
Lordship, yes.
has been nullified.
Yes, Lordship.
Then purchased by state.
Yes, Lordship.
Okay, then
And to that effect, Lordship, a seal deed was executed between the parties.
okay.
And there's a clause in the seal deed, Lordship,
Mm.
which provides that all the present appointment to bid for posts being held by the landowners and the college establishment will further maintain. That is one,
Will be maintained.
yes,
Appointments already made will not be disturbed.
yes. So, Lordship,
Okay, then
in view of that clause, Lordship, the petitioner was under obligation that she has a right for access. However, by filing the affidavit in opposition by the respondent, Mr. Respondent, as well as the private respondent, the picture turned to be different, Lordship. Mr. Respondent is this time that there is no land owners right for post. However, in my writ petition, Lordship, I've taken a specific statement that even if there is no land owner right, a public force should be filled up.
correct.
So I'm not much pressing on land ownership basis, Lordship. So
Okay.
my prayer is to fill up the motion question by publishing advertisement. That is my short.
You are interested in grade 3, grade 4. What is your qualification? For which post?
So pray for us.
Grade 4. You you have the eligibility, qualification.
Lordship.
You aspire to participate in the process of recruitment if it is held in process of law, which has not been held.
Yes.
And you say that the respondent number 5 has been inducted without any process. And you are from the biddings exchange, you have almost abandoned the other aspect, that landowners.
Lordship.
Okay, state
Lordship, may kindly come to page 18 of my writ petition.
page 18. Yes. Yes.
This is the first memorandum issued by the state government, Lordship.
Yes.
Paragraph 4 is relevant, Lordship.
Hmm. Yes. Yes.
And Lordship, may kindly come to page 33.
33.
Yes.
Yes.
My writ petition, Lordship. is another office memorandum dated 14/2/5. Because Lordship, the public respondent of 5 was appointed against the most vacated by the military tribunal of Burma.
Mother.
That is admitted in the government affidavit as well as affidavit filed by government respondent of 5.
Okay.
I just want to relay two judgments.
Please.
First Lordship, 2019 2 GMT,
2019 2 GLT
277.
277.
For judgment similar text Lordship.
Yes, please. Name.
Partition Lordship. This also from Nagaland Lordship.
Okay.
Dimakam versus State of Nagaland.
Okay. Which paragraph?
That's a short judgment Lordship.
So,
Paragraph 9. Paragraph 7, 9, and 10. Lordship. Although the writ petitioner in this case, Lordship, blamed for appointment of land of the person. However, during the course of hearing, no right of the land. Therefore, Lordship, this honorable court dispose of the writ petition with the direction to fill up the post in question in accordance with law by advertisement. Lordship.
This is not required to be cited. This is the normal process. Any public post has to have to be filled up in a transparent manner.
The second one, Lordship,
Yes.
2011 3 SCC. 2011 3 SCC.
PSCC, yes.
436. Order 35 and 36. This is on the same issue, Lordship.
Para
35 and 36.
35, 36. Open advertisement. Okay.
So my limited prayers for opposition petition should be advertised and fill up by inviting application from eligible candidates. In terms of the OMR,
And you have additionally challenged the appointment of respondent 5 on the ground that the restrictions imposed by 14/2/2005 would be applicable in her case, as her mother was a government servant who had voluntarily retired. And there are the restrictions. Yes. No, we'll hear the state first.
Yes, Your Lordship. Your Lordship, as far as the ownership of the land is concerned, it is established that as per the sale deed dated 15/5/2008.
No,
the
leave
ownership
aside,
has been
leave aside the point of donors, landowners. That is out of, we are not even
Yes, sir.
adjudicating.
Yes, Your Lordship.
How was the respondent 5 inducted in the process or in the post?
As I've mentioned in my affidavit in opposition, para 6. Since on the vacancy being available in the college, and since respondent number 5 was a sole applicant at that point of time.
No, did you go for an advertisement?
No, Your Lordship, no.
How can you fill up them?
For such a post, it was immediate necessity.
Immediate necessity
So-
may require you to have a very temporary kind of an arrangement. You cannot induct for in a permanent basis. You have to give everybody a chance.
Yes, Your Lordship.
Even if we do not go into the aspect of restriction under 14 to 2005, being a relative, not being a relative, even everyone, she might also get a chance and she might be appointed, but the right to compete, you cannot take away that right. Right of fair consideration is a basic right. That is all. You file affidavit otherwise.
Yes, Your Lordship.
Yes, madam.
Yeah, please, my lordship, here the respondent's mother took voluntary retirement because of ill health. And voluntary retirement was, there is a consideration, compassionate appointment as well as voluntary retirement on ill health ground, lordship. It is precedent, there is a consideration that may be considered. My second aspect is that the petitioner has no locus standi to file this writ petition because she was no longer a landowner. 6 posts have already been granted to landowner, appointment has been granted to landowner basis to those donors, including the petitioner's father. 6 appointments have already been done. What has happened is, at that particular time in 1985, when the petitioner's father donated land, he sold away his lane to land ownership appointment to the present petitioner's mother. My lord will kindly.
Are you contending that the father of the petitioner already got the benefit of appointment?
Yes, lordship. Lordship will kindly come to page 1. He sold away by accepting rupees 6,000.
No, that is okay, but
Okay, lordship.
he,
So
no,
when he,
no, was the father's recruitment done in the capacity of a land donor or in a validly held recruitment process
previously
as a land donor?
as a landowner, here the question is in Nagaland that there is a specific land holding system where grade 4 appointments are considered for land donors free of cost. Those who provided land free of cost to the government establishment, lordship. So in 1985, when these 6 landowners, when their land was donated for establishment of Zineboto Government College, when Zineboto Government College was established, basing upon 6 landowners' land combined, 6 appointments were already provided. So at that particular time, this present petitioner's father, annexure 1, page 6, he sold away that his lane to land ownership appointment to the present respondent's mother by accepting rupees 6,000. The agreement is at page 6.
Madam, it will ultimately boil down to the issue. The present claim is not on the basis of being the son of a land donor. Had it been a claim that he is a family member of a landowner, then matter would have been different. Your contention.
Her petition is, her claim is that
No,
they are the landowner and they should be considered as per the agreement. That is what.
Let us see the prayer.
Possibly can you turn to why?
Let us see your prayer.
Paragraph 15 of
Yes.
writ
No, let
petition.
us see the prayer. Everything will be okay, clear.
That's why he has no locus. She has no locus standi to come before this honorable court. That is my humble.
Page 13, Lordship.
The council, your prayer is on land ownership basis.
Yes,
Yes,
exactly. That's why he has no locus standi to challenge and
You could have challenged it on the other issue.
Lordship,
Where
can
are
you
your
come to-
grounds?
Kindly come to paragraph 15 of my.
It's not about the paragraph, it's about the prayer that is prayed before this honorable
My
court.
statement,
Paragraph?
paragraph 15. Hear it, Lordship.
Yes.
So that is my specific discussion. It should be advertised.
Something to fall back upon. Alternative.
Yes, that's why, Lordship. In the first place,
If there is.
she has no locus standi to file this writ petition because she sold away, her father sold away the lien to lien
That
ownership
is
in two
disputed
thousand.
question of facts, Lordship. I have replied
When
to
there-
my reply.
No,
I
Lordship,
find
the
my reply-
Just a
documents
minute,
is
just a
here.
minute. Just a minute, one by one.
Yes. I've already filed my reply.
Lordship can
affidavit.
kindly peruse annexure 1. The documents are placed before this honorable court. A person who has sold off his lane as landowner is coming again basing upon that clause. That clause also he has submitted before this honorable court. He has come claiming for land ownership. In 89. 89 sold off. So where is the locus standi to challenge coming here as landowner? Their prayer number 2 is specific, Lordship, only on land ownership. So we go by prayer. The pleadings go by prayer, Lordship. So the question is whether, when she is not a landowner, whichever way, whether the appointment can be interfered. That is another question, Lordship. That is another issue.
But what about the office memorandum, the restrictions, 14 to 2005? How do you overcome that? Leaving aside this aspect, 14 to 2005 is a clear restriction.
So here what has happened is, Lordship, they got appointment prior to 2005, as well as in 2008, they got 1 crore, again compensation.
No, not on that. How do you overcome your restriction laid down by OM dated 14 to 2005? The restrictions that you are the son or daughter of a government servant who had gone for voluntary retirement.
Lordship.
You cannot be appointed.
I
The-
beg your pardon, Lordship.
The aspect of compassionate ground is a wholly different concept.
Lordship, here my humble submission is that my mother was sick and voluntary retirement was applied, and due to her voluntary retirement, I was appointed. And
You
Lordship,
you cannot be done in view of 14 to 2005.
Lordship, yes, office memorandums and the notification are there, but in a
Yes.
certain case, Lordship, voluntary retirement basing upon medical ground
No, that's
is
that's a
considered.
different matter. Voluntary retirement for some other reasons. Compassionate ground appointment is a wholly different factor. Now, voluntary retirement is a different factor. If there is a restriction,
Lordship,
how has the state responded to this? How have we responded to 14 to 2005? The case which has been projected on 14 to
Lordship, you
2005.
find my reply in para 6 of my.
Yes, what have you stated?
That since the respondent 5 being the loan applicant, the sole applicant, therefore his application was considered by the department in interest of public. Yes. Yes. Gradually processed through the government. Lordship. And the post of, mentioned in that post of MTS is not mandatory to have a interview. Hmm?
Ominous sign for whom? This side or that side? The ominous signs for which side? Petitioner side or respondent side?
Probably the respondent.
Probably. You have got the message signal from above, from nature. After all, public employment, madam, cannot withstand. Okay, please write.
Lordship, my first number for question is whether the petitioner is locus standi.
We will consider. The appointment of the respondent number 5 as multitasking staff in the Junhe Government College is the subject matter of challenge in this writ petition. Full stop. Para. Before going to the grounds of challenge, comma, it would be convenient if the facts, comma, bereft of details are narrated below. Full stop. Para. The Junebuto Government College, within bracket, hereinafter the college, was established in the year 1985, and at that time, comma, agreements were executed between land owners for donation of the land. Full stop. It is the projected case of the petitioner that his father was one of the land donors. Full stop. The lands were, however, purchased by the state government in the year 2008. Full stop. The it has been projected that the mother of the respondent number 5 was an employee of the college who had taken voluntary retirement on 11/1. What it is, that's their case. We'll come to your case. On 11/1/2023, whereafter the respondent number 5 was appointed. Full stop. It is submitted and it is projected that such appointment was not preceded by a recognized process of recruitment, whereby the petitioner, along with other eligible candidates, were deprived from a fair opportunity. Full stop. It is this appointment of the respondent number 5 which is the subject matter of challenge in this petition, comma, as indicated above. Para. I have heard Sri Sri Learned Counsel for the petitioner. First of all, I have also heard Sri Sri Learned State Counsel, whereas Ms. Sri Learned Counsel appears for the respondent number 5. The contesting parties have filed their respective pleadings. Para. The learned counsel for the petitioner has, by relying upon office memorandum dated 4/6/2016, has submitted that all grade 3 and grade 4 posts are to be filled up by a validly held recruitment process from a full stop. He submits that the said office memorandum is in consonance with the settled principles of filling up settled principles of public appointments. Full stop. Reliance has also been placed upon office memorandum dated 14/2/2005, by which a restriction has been laid for appointment of the kith and kins of government employees who avail voluntary retirement. It is submitted that though the petitioner, though one of the legs of challenge as well as the claim was on the aspect of the land donation, in view of the facts emerging that the land was subsequently purchased by the state, the learned council has submitted that he would that the other grounds of challenge would still be available to him. Full stop. The learned counsel for the petitioner has relied upon the cases of so and so, wherein the aspect of maintaining transparency and fairness in public appointments has been laid down, which necessarily require require publication of an advertisement. Please have your seat. Para. The per contra, the London State Council, by referring to the affidavit in opposition filed on 21/3/2024, has submitted that there were justification there were justifications for appointment of the respondent number 5, the loan candidate who had applied, and there was an urgent need for filling up of the post. Full stop. He has also submitted that the respondent number 5 fulfills all the eligibility criteria. Full stop. Supporting the stand of the state, The learned counsel for the respondent number 5 has, however, questioned the locus of the petitioner to maintain the present challenge. Full stop. It is submitted that 6 numbers of appointments of land donors were already done, which includes the father of the petitioner. And therefore, the petitioner cannot make a further prayer for appointment on the basis of land donor. Full stop. The learned counsel has specifically referred to the prayer number 2 in the writ petition in this regard. Full stop. Para. As regards the restrictions imposed by the OM dated 14/2/2005, it has been contended that the mother of the petitioner, who was an employee, had to take voluntary retirement due to ill health, and taking a sympathetic view from the respondent number 5 was appointment. It is reiterated that the respondent number 5 fulfills all the necessary qualifications and eligibility for such appointments. Full stop. Para. In his rejoinder, the learned counsel for the petitioner has submitted that though the prayer number 2 has been relied upon, has been pressed into service by the respondent number 5 while questioning the locus of the petitioner, specific averments have been made in the writ petitions. More specifically, in the writ petition, and in this regard, paragraph 15 has been pressed into service. Full stop. Para. For ready reference, the averments made in paragraph 15 of the writ petition are extracted herein below. Please 12. No? Green flag. Side. Para. From a reading of the writ petition and the prayer, it appears that while petitioner is claiming the appointment in the post held by the respondent number 5 on the basis of land ownership, such the other aspect of the challenge upon the appointment of the respondent number 5 is, however, on different footing and grounds. Full stop. As expected, as observed above, a specific pleading has been made on the manner of appointment of the respondent number 5, which appears to be done without calling for any advertisement or holding any validly recognized recruitment process. Full stop. The reliance upon the office memorandum dated 14/2/2005 also appears to have sufficient force, as it is not disputed that the mother of the Respondent number 5 was an employee of the college who had gone on voluntary retirement. Full stop. Para. The aspect would have been entirely different if the petition was structured only on the ground of claiming the appointment in a vacant post in the college. Full stop. This court has also been informed that the father of the petitioner had already got the benefit of appointment as a land donor, and by the clause in the sale deed executed in the year 2008, such appointment was not disturbed. Full stop. However, the present post which which has been filled up is not on the basis of any land donor, but a normal appointment, which is mandatorily required to be preceded by a fair process, which includes an advertisement and voting, a proper selection in accordance with law. Full stop. The materials on record do not suggest or show that any such process was adopted before filling up of the post by the respondent number 5. Para, under the aforesaid facts and circumstances and discussions made, and also taking into account the settled law on the aspect, the appointment of the respondent number 5 as MTS in the Junebuto Government College is not sustainable in law, and accordingly, the impugned order dated 2012-2022
2012 is the approval order.
impugned approval order dated 28th of December 2022 and the appointment order dated 11/1/2023 are set aside and quashed. Full stop. Consequently, the post is directed to be filled up by following the due process of law, in which the petitioner, as well as the respondent number 5, would be can participate if eligible, and their candidatures are to be considered fairly and at par with the other eligible candidates. The petition accordingly stands disposed of.
Obliged, Lordship.
For admission, item number 9.
Item number 9. What is this? WPC 211, this matter can be gathered for appreciation. Yes, State Council. It is submitted that there is another similar matter, WPC 211 of 2023. And both these matters can be taken up together. Full stop. Para. It is accordingly directed for listing of this matter along with WPC 211 of 2023 after a week for admission hearing.
For admission, item number 13 to 18. 13 to 18.
Yes, madam, what are these?
Lordship, in the affidavit of opposition stated by the state respondents, it has been stated that the state government has constituted a high-level committee, state committee by notification dated 16/02/2024. The committee was entrusted to formulate a suitable policy for regulation of pay, remuneration, and conditions of
That minimum
service.
pay.
Yes, Lordship. Service of contingency.
Yes,
and
yes.
Fixed pays.
Yes, we have read this.
Okay, in view of this, the opponent prays for seeking time till the outcome of this policy. So if we wait for the outcome of this policy,
It has been jointly submitted by the Learned Council that towards the redressal of the grievances of the petitioner and similarly situated persons, a committee has been constituted by notification dated 16/2/2024 to suggest suggest appropriate measures. Full stop. 16/2, is it? 16 February,
Yes,
March,
sir.
April, May. 3 months have passed. In the interest of justice, matters are accordingly adjourned by 6 weeks. Full stop. The Learned Council for the parties are, however, given liberty to make a mention in case any decision is rendered by the committee in the meantime. Just after 6 weeks. I think they have said about 6 weeks.
For orders, item number 19. Item number 19.
May I please, Your Lordship? Lordship, by order dated 26/4/24,
Yes.
this court has allowed to take fresh steps upon respondent number 6, Your Lordship, and accordingly I have taken,
When did you take steps?
Lordship, on 29th,
29 when?
29/4/04/2024, Lordship.
Service upon this conversation was statement. So 29/4.
I have a short,
Okay.
I have a short
Uh,
prayer, Lordship.
Yes.
Lordship, this is the second time we have taken the steps upon the respondent number 6. And we have taken in his official address, Lordship, in the office of Principal Chief Conservator of Forest, Lordship. So my prayer before Lordship will be that the service of notice upon respondent 6 may be treated as complete, Your Lordship.
This time the service is not returned and you have taken steps on 29/5.
29/4,
29/4, it's not a month. Today is what?
exactly 1 month. Your Lordship.
Let it be to 1 more week, okay?
Lordship.
Office note dated 21/5/2024 reflects that the notice upon respondent number 6 was issued by registered AD post on 30/4/2024. What's the para? List after 2 weeks. Full stop. Since it is submitted that it is for the second time that steps have been taken without there being any confirmed reports on the service, appropriate observations may be made for deemed service. The aforesaid submission will be considered on the next day.
Obliged, Lordship.
For hearing, item number 22. Item number 22.
Yes,
Please, Lordship.
22, yes.
Lordship, this matter relates to cancellation of my petition order. Lordship may directly come to page 30, Lordship, in my writ petition, and accept 10, Lordship. That is the impugned order, Lordship.
Age
Page 30, Lordship. and
30.
30, Lordship. This is the order passed by the respondent number 3, Lordship. Annexer 31, wherein the effective portion, Your Honor, Your Lordship. May I read, Lordship?
Yes,
Whereas the first paragraph, Lordship, of page 31, Lordship.
yes,
Whereas Sri Sikiho Sema and Sri V. Imato Sema has been allotted an area of so-and-so land by Government of Nagaland Land Revenue Department letter so-and-so dated 29/1/1985 and ADC's order dated 18/2/1983, and accordingly Patta was issued in favor of Sri Sikiho Sema bearing Patta number 643. Subsequently, the same was mutated in the name of his son, Sri Pihokis, that is the petitioner here in Lordship, by mutation case number so-and-so dated 14/9/2015. However, till date, the revenue record does not show the issuance of Patta in favor of Sri V. Imato Sema. He is not before your Lordship. It is also an admitted fact that the allotment order dated so-and-so is subject to fulfillment of certain conditions, inter alia condition number 1, wherein it is stated that the allotee shall take possession of the allotted land within 6 months. However, the same was not complied with within the stipulated time frame. Condition number 7. It is a clear pointer whereby it is stated violation of any of the above terms and conditions will cause his settlement cancelled. Therefore, on this count alone, the allotment order dated so-and-so is found to be invalid, Lordship. Lordship, the whole dispute arose. Whole dispute is regard to dispute as regards possession, Lordship. Which was better before respondent number 3, Lordship.
who is for the private respondent? Who is for the private respondent?
He is the respondent number 4.
Who, you have filed your affidavit?
Yes, Lordship.
And who is for the state? Yes, madam? You filed your affidavit?
Yes, Your Lordship. Yes, Lordship.
What do you say? In this matter, what do you say?
Your Lordship, my stand is basically in para 8, 9, and 11, Your Lordship. Here, we're saying that the impugn order, this was passed after meticulously examining all the documents, and also after those documents used by the respective parties, the LRSO report, and the oral submission of all the parties, Your Lordship. Therefore, this impugn order was not passed mechanically, but this all factor was taken into consideration, Your Lordship. In my affidavit, Your Lordship.
You're tired? Sit, have your seat for some time. You run to the court or what?
Your Lordship, sorry.
Have you run to the court? You seem to be out of breath, short of breath. You seem to be short of breath. Take your seat for some time.
That's all I told.
We'll hear you after 2 minutes.
That's all I Your Lordship.
2 minutes, no problem.
Thank you.
Yes, madam, you can proceed.
Yes.
What is the case about?
Lordship,
Who
the
are
whole
you?
dispute arose as regards possession, Lordship.
Who are you?
My father got the allotment from the government, which is quite prominent in the impugned order, Your Lordship. They have admitted that fact, Lordship.
Where is the order of allotment?
Annexer 1, Lordship, at page
Page?
14.
1/4.
1/4, Lordship. It is the letter dated, Lordship, 2/11/84, Lordship. It is a proposal for settlement, Lordship. My father's name was at serial number 1, Lordship.
Just a minute.
Sri Sikiho Sema, Lordship.
Just a minute. Just a minute. Go slow. What is the date?
2/11/1984.
Serial 1.
Yes, serial number 1, the name of my father, Sikiho Sema.
1K 5L.
Yes, 1 kata 5 lesser, Lordship.
Okay. Thereafter,
Thereafter, Lordship, annexer 2 at page 15, Lordship, that is the allotment order, Lordship.
okay.
issued in the name of my father, Lordship.
18 December.
Yes, Lordship.
Allotment order.
Allotment order, Lordship, wherein there are certain conditions, Lordship. There are 7 conditions, Lordship. The allotee shall take possession of the allotted land within 6 months
Yes.
before construction and specification, and the plan the building should first be approved by so and so. Subletting of the plot or any part thereof is strictly prohibited. For the allotted land shall be demarcated.
Okay, then,
By-
yes, then,
Yes, thereafter, Lordship, Annexure 3 is the Zamabandi in my name, Lordship, after the date of my father, Lordship.
father took possession.
Yes, Lordship. There is a clear statement to that regard in paragraph 8 of my writ petition, Lordship. Paragraph 8, Lordship, that upon entering into the possession of the land while the father of the petitioner was enjoying the land as bona fide owner, he was provided with land patta in respect of the above said land measuring 1 katha 5 latha, bearing patta number 643 under Dag number 722 stroke 1296 722 stroke 1295, that is 2 Dags of Dimapur town block number
Okay.
5 and Moja number 2,
Then
Lordship.
father passed away.
Yes, Lordship. Thereafter, the land was mutated in my name. Before passing away, he gifted the land in my name. The mutation order is clear, Lordship. Mutated and transferred into the name of Sri Piho Kits by case number so and so, dated 9th December 2015.
This
Lordship.
Jamabandi at page 16 is, this is you.
Yes, Lordship.
Piho kids.
Piho Kits, Lordship.
Okay, petitioner.
Thereafter, Lordship, Annexa 4 other revenue.
What is the remark?
Mutated and transferred in the name of Sri Piho Kits by case number so and so, dated 9/12/2015.
Okay, there was a mutation case
Yes, Lordship.
in which your name was,
Yes, Lordship.
and thereafter the Jamabandi,
The Jamabandi was issued in my name, Lordship.
okay. Then what-
Annexa 4 other revenue clearing receipts, Lordship.
Yes.
Then Annexa 5. The story starts, Lordship. Annexa 5, Lordship, at page 18, Lordship. It is an application which I have filed before the respondent number 3, Lordship, as regards issuance of restraining order, Lordship.
Why? Why restraining orders you required?
Yes, Lordship. The para 2, Lordship, I have stated, Lordship, in that application, Lordship,
What is
that
the
all.
date, what is the date of this?
Lordship, Annexa 5, Lordship, it is 29/2/1968, 2016, Lordship.
You filed for the DC.
Before the respondent number 3, Lordship.
Why? What has happened?
Yes, Lordship, that is what I have explained, Lordship. On 21/9/2015, the survey was conducted by the surveyor and the land was demarcated with pillar post. That after some time during the month of December 2015, I visited the said land to clear the areas in the said land has not been occupied since the allotment, but found that some unknown persons were carrying on development work claiming the said land to be their land, whereas I am in possession of the valid documents to prove that I am rightful owner. As such, it is requested that your esteemed authority may kindly issue restraining order to the above mentioned land, Lordship. Annexure 6, Lordship, is the letter application submitted by respondent number 4 before the respondent number 3, Lordship, dated 22/7/2016, Lordship, wherein they have also claimed that at page 21, para 3, Lordship, of that
This
annex.
is by R4
Yes, Lordship. Private respondent, Lordship.
to Deputy Commissioner
To the Deputy Commissioner, Lordship.
for settlement.
Not for settlement, Lordship. They have also complained about certain disputes as regards possession, Lordship. At para 3 in page 21, they have stated the petitioner started construction over the said land. In the meantime, while the constructions were in progress, to utter surprise, one person representing Piho Kits and V. Imato Sema came to the site along with some documents sometime in the month of June 2016. That is, Lordship, may kindly take note of the date, Lordship. Whereas I have complained about the disturbances on Lordship 29/2016, Lordship. They have complained about it in 2016 June, Your Lordship, from February till June.
Where are you reading?
I am reading at page 21, Lordship, para 3.
Yes.
Came along with some documents sometime in the month of June 2016 and requested upon the petitioner to stop the ongoing constructions, consequent upon which the petitioner instantly ceased the constructions with the condition that no party will execute any work in the said land till the matter is settled. However, to utter surprise, the opposite party on 21/7/2016 started construction over the land in question despite our protest in violation of our verbal understanding.
Okay, then.
Then Lordship, at page 22, annexure 7 is the restraining order issued by the respondent number 3, Lordship.
Dated,
Dated, Lordship, 27/7/2016. Whereas I have filed a petition, Lordship, my petition was filed in the month of February 2016. No action was taken on that petition, Lordship. The respondent number 4, private respondent, filed a petition on 22/7/2016, and on 27/7/2016, the restraining order was passed, Lordship. It has been brought to the notice, I am reading, Lordship, at page 22. It has been brought to the notice of the undersigned reference the representation submitted by Reverend N. Procedural Pastor Daba, that the land purchased by Daba covered the patta number so and so area of 1 bigha 2 kata 10 lesa at block number 5 has been counterclaimed by the representative of C. Piho Kids and B. Imatosema, which may create undesirable situation on the land. In view of the above, both parties, no mention about my application has been made, Lordship.
doesn't matter, this is a restriction order,
Thereafter, at page 23, annexure 8, Lordship,
yes,
is the so-called notice issued.
okay.
So-called notice issued to both the parties, Lordship. Page 23, may I read, Lordship?
Yes, no, we have seen this, thereafter,
Annexure 9A, Lordship. This is important, Lordship, at page 24, Lordship. There is a typed copy of this, Lordship. This is a letter referring, this is a report, Lordship, dated 18/1/1988. That is after issuance of settlement order in favor of my father, Lordship. At page 25 is the typed copy, Lordship. As per ES's remark on the body of the government letter dated, so I have verified the plot allotted to Mr. Sikiho Sema on the part of Dag number so and so, measuring an area of 1 kata 5 lesa. Further, in 1984, as part of then ADC's order, I have measured the land with ASCII of Mr. L. Seiza under Dag number 265, measuring an area of 32 bighas of block number 5. L. Seiza is the predecessor in interest of respondent number 4, Lordship. And it was found that he is on occupation of some excess land which is now under his fenced area. However, as directed by the ADC, I have prepared trace map of 9 plots, and accordingly, this office has forwarded proposal for 9 individual along with Mr. Sikiho Sema, and accordingly, government has approved the proposal in favor of Mr. Sikiho Sema and 4 others. By government letter dated so and so, dated 29/1/1985. But while going through the relevant file, it is found that Mr. L. Seiza is claiming the entire area which is already allotted and under proposal, Lordship. At page 26, there is another report, spot verification report, Lordship. 27 is the typed copy of that report, Lordship. As directed by the ADC, DMR, and LRSO by order number so and so, I have done the spot verification along with the application for demarcation of the plot. Demarcation, the plot falls under block number 5, part of Dag number 80, within bracket 1/80, measuring an area of 1 kata 5 lesa. The plot
just a minute. Okay.
The
Yes.
plot covered by PP number 643 in favor of Sri Sikhiyo Sema White Government Letter Number so and so dated 29/1/1985. The land in question is found occupied by Ranu Seja. The way by wire fenced. Submitted report for your information and necessary action, please. This is the report. Thereafter, Lordship, Annexer 9C, Lordship, at page number 28.
Just a minute.
This is the plot identification.
Just a minute. Isn't this in the form of a 144, 145?
Yes, Lordship.
Then
That is what my submission is, Lordship. While deciding a disputed question of possession, Lordship, the respondent number 3 has decided the question of title, which he has no jurisdiction to pass before, because after issuance of patta in the name of my father and Jamabandi in my name, Lordship, the jurisdiction lies in the civil court, Lordship, for deciding a question. That is what my husband submission is, Lordship. That while deciding the disputed question of possession, Lordship, and while in at
have
base,
you instituted any suit? In the meantime, have you instituted any suit?
no, Lordship. As the matter is pending before the Honorable High Court, Lordship, I have not filed any suit, Lordship, because this matter has not yet been decided, Lordship. Status quo order has been issued by the Honorable Court, Lordship, and I am in possession of the land, Lordship.
See, this proceeding was thought to be instituted by you, but no proceeding was initiated.
Lordship.
Now, ultimately, on the application filed by the respondent number 4, the proceeding has been instituted. Though 144, 145 has not been specifically written, but the process appears to be one under
yes,
that.
Lordship. Where at the restraining order it is mentioned, Lordship.
The deputy commissioner acting as the DM, he has passed an order. While passing the order, apart from the question of possession, he has also said something on the ownership. Ownership. We can clarify the issue because our role as a writ court will be very limited in proceedings on the 145. In fact, you have remedies in the law elsewhere. But this appears to be a settled principle that the powers under 145, 144 are not to be exercised for, or it's not, there is no jurisdiction to say anything on the ownership.
Yes,
it has to be done in a civil proceeding. Yes, madam, what do you say?
On that aspect, I agree with you, Lordship.
Because, the case projected by the petitioner would obviously be deferred by the case which should be projected by the respondent number 4. Both will be claiming ownership on the land. So at this stage, we may not be equipped or have sufficient materials or even have the jurisdiction to say anything on facts. This is not the court on facts.
Yes, disputed
Court
question.
on facts is elsewhere. Both the parties can lead evidence and the court with jurisdiction can come up with the findings on the fact regarding the ownership. At that part, we can leave it open, but so far as maintenance of status quo, it will be there for a particular period, and along with the civil suit, which may be instituted by either of the parties, they can file injunction application. Till consideration of such injunction application, the order of status quo will be there. We'll not make it indefinite. We'll say maybe within a period of a month from today. Because this observation on ownership, I think it's not within the ambit of the officer. Yes, what do you say?
In the instant case, the petitioner is not the owner. He doesn't possess the landowner even for a split for the seconds. Lordship, coming back to the impugn order, which was passed by the Deputy Commissioner. Lordship. Lordship, I am allowed to read this. My lord, the page 12. Yes.
31.
Yes. The last part, Lordship, I'm allowed to read, my lord. It is also expedient to mention herein that the order dated 17/3/2009 passed by the Deputy Commissioner Dimapur, Nagaland, whereby it is established that Mrs. Mrs. Shaiza is a legitimate owner and on the strength of which she had sold out her land to Shri Daniel Longjar, from whom the complainant, Lordship, it's me, from whom the complainant Dapa means Lordship, Dimapur All Baptist Church, I represent the church, had purchased the suit land in view of which there is no doubt with regard to ownership of the suit land. Therefore, taking into consideration of the above facts and circumstances, and having meticulously perused all the relevant documents on records, I am of the view that complainant had established the case, and in view of which it is made clear that the complainant, Dimapur All Baptist Church, is the rightful owner of the suit land. In view of the above, the claim made by Shri V. Hokits and Shri V. Imato Sima, though the attorney holder of Shri Kakaho Aomi, is hereby dismissed. So, Lordship, the question is now coming back to the allotment order. Lordship,
Yes.
the allotment order, that is page number
15.
Lordship, my lord, page number 15.
Yes.
This is an allotment order with the condition that to fulfill the certain terms and conditions.
Correct.
Then only the LOD will become the owner.
Correct.
Unless and until the conditions are been fulfilled, the LOD doesn't have any authority of the land. Lordship, my lord. So in that view of the matter, the Deputy Commissioner, the revenue officer, doesn't interfere with this order. He just said that the claim of the Vito kids, the petitioner, is dismissed. He didn't interfere with this order, Lordship, because this order is not alive. Because it was supposed to be implemented if he possessed the land within the period of 6 months.
Correct.
Then only the order will become live. But now the lifeless order, there's no point to interfere with the lifeless order, Lordship. There's no life at all. This was for a period of 6 months. Within this period of 6 months, if the petitioner can possess the land, then he becomes the owner of the land.
No, how do you know that the petitioner has not, petitioner's father did not take possession of the land?
Lordship is very clear.
From where?
Lordship, from their representation itself.
Yes.
Lordship is kind of turn to
Page?
page number 18.
118.
18, my lord.
Yes, please.
Page number 18.
Yes.
Let me read the relevant portion, my lord.
Yes.
The second paragraph, my lord. That, sir, the said land has been allotted to my father, Shikiho, in the year 1985, white leader number so and so, dated 29/1/1985. And thereafter, the land was gifted to me by my late father during his lifetime. Out of natural love and affection, by executing a gift deed bearing registration number so and so, dated 8/12/2015. And as such, I am now the absolute and lawful owner of the said land,
Yes.
measuring an area of so and so,
Correct.
covered by bata number so and so, at Moza number 2 at Dimapur. That, sir, on 21/9/2015, the survey was conducted by the surveyor, and the land was demarcated with post pillars, with pillar posts. That after, my lord, this is important, that after some time during the month of December 2015, I visited the said land to clear the area since the said land has not been occupied since the allotment. So lordship, the question of possessing does not arise. Till this state,
No, Mr. Council, what is the difference? What is the meaning of occupied and what is the meaning of taking possession?
Yes,
lordship,
that is quite a.
to occupy means he had to possess that, he had to do some construction.
No.
Lordship. Nothing has been mentioned about
Then
lordship.
that is not the meaning of possession.
No.
To possess a property, you need not stay there. You did not have a house
Occupation,
there.
staying.
Madam, have a sip. What is the meaning of possession?
Lordship, the land was not under the position of the petitioner's father. Not at all. Lordship, there are some. Petitioner's father. Lordship. I just received.
No, no, where?
These are not part of the record. These are not part of the records.
Lordship.
In your affidavit, where is it in the affidavit?
Lordship, in my affidavit, I have mentioned very clearly.
Let us see. No, see, there are certain things. You may be very correct in contending that the conditions were imposed for making the allotment order in favor of the father of the petitioner. Before it came into operation, he has to fulfill 7 conditions.
Yes.
One of the main condition was to take possession of the land within a particular period.
Very much.
Particular period. Now, there is also a document. So there is a document at page 16.
Lordship.
16, which is a Jamabandi in favor of the present petitioner. This is
My,
of the
my lord, this was issued in 2018.
2015.
2015 only,
15.
Lordship, 2015 only.
Now, the question of the possession not being within the father gets belied by the fact that a Jamabandi was issued in the favor of the petitioner. Before a Jamabandi is issued, a exercise is done, a verification is done, who is in possession. Beauty is done only on the basis of possession, nothing else.
The position was to be made within 6 months, that's clear.
Yes.
Nothing more. Now, then where is the bata of the petitioner's father? Lordship. Petitioners, unless we have related this land from his father's bata, then where is his father's petitioner's father's bata? Because this was been done in 2015.
This patta has been said 643. You have not given the number of the patta 643.
So where is the petitioner's father's bata in fact?
You have given the patta number 643.
Pata number, so that is quite admitted in the impugn order. That is quite admitted.
No,
Even
Mr.
though
Council,
the Pata was issued, it is admitted.
all said and done.
It is admitted at page
It is
31.
all said and done. The Deputy Commissioner doesn't have the jurisdiction to decide on the ownership.
Lordship, Deputy
And number 2, nobody has challenged the allotment order or made a representation before any judicial authority to set aside or to hold for a declaration that the allotment order has spent its force.
Lordship.
That is not your case. You are not before this court. You are a respondent.
Lordship, I am an innocent buyer. I am a church. I bought the land from Mr. Daniel Longchamp.
We are not saying anything on the ownership. That will be decided by the appropriate court of jurisdiction.
So now, Lordship, the question is that if the petitioners claims that petitioner's father had bought the bata with regard to the particular allotment, then where is the petitioner's father's bata in fact?
It will be seen by the civil court. Where is our scope to see?
No, my lord, if Vito Gates is claiming that he have mutilated his land, basing on the gift deed, and Lordship coming to the
Have you challenged the Jamabandi?
My lord,
have you challenged the Jamabandi?
Lordship was not before us. It was not before us.
No, you have gone for the deputy commissioner only because of the position aspect, which
My
has been held
lord,
in your favor.
My lord, then lordship, if Jamapandi, if the land has been mutated on the strength of gift deed, on the strength of gift deed. In the entire petition, from paragraph 1 to 29, there is not even a whisper about the gift deed, lordship. So my
Mr.
lord,
Council, you're mistaking everything. We are not saying anything on the facts. Neither is this petition on the ownership aspect, or this petition is only challenging that aspect of the. The challenge is to that aspect of the impugned order, whereby while deciding the question of possession, he has gone one step ahead and has also said something on the ownership, which is not within the ambit of a deputy commissioner acting as the district magistrate. This is a proceeding akin to 145, 144 of the CRPC. So the ownership aspect has to be ascertained in the appropriate civil code, where you can also have a counterclaim that you are the owner. They can also have a claim that they are the owner. Whoever has the papers, their ownership will be decided.
lordship is,
But deputy commissioner, he was not having that jurisdiction. He's not a civil court.
lordship, deputy commissioner doesn't intervene with the allotment order, lordship.
The allotment order was not the part of challenge itself. He could not have been before a deputy
So,
commissioner.
lordship, the deputy commissioner had just passed the order saying that the claim of the respondent for, or the claim of the petitioner.
So far
is
as
not
possession,
survived.
possession is concerned, he may be correct that their claim to defend their possession, that is not enough for possession. But while saying that, he has said something on the ownership aspect also.
My lordship, the survey was conducted twice, wherein the petitioner had cooperated. The spot verification was done twice, lordship. Based on the spot verification, DC being the revenue officers, and the complaint was then lodged to the DC. Based on that, DC have saying that yes, your claim doesn't survive. So in that view of the matter, based on the survey report, lordship, the DC have passed petition order. So lordship, you can see the survey report also. Twice the survey was initiated.
Let us assume that the survey report is totally against her. Totally against her, wholly in your favor. Will the DC get the power to say something on the ownership? Just tell us something. Has the DC got the jurisdiction or power to say any declaration, to give any declaration on the ownership aspect?
Lordship, in my opinion, in my respectful opinion, DC do have authority because.
Sorry, that is not a correct understanding. You read 145. That is not a correct
Lordship,
understanding. This is not a civil court, Mr. Counsel. Don't go into matters which have been settled. The DC has the power to say something on the ownership. This is a settled position. So as some law, the DC has got a power in the 145 to say something on ownership.
My lord,
You cannot. There are hundreds of laws. You are aware of this.
Lordship.
We'll give you protect the interest of both the parties. We'll give them a month's time to approach the civil court for declaration of right title interest. You will also have the liberty to approach, or you can file a counterclaim.
Lordship, in that view of the matter, a specific time has been given.
We'll give a month's time.
Since 2018.
Yes,
the
month's time.
constructions are
Yes,
installed.
1 month, maximum 1 month. If they do not avail the time, everything will be this stay order will be vacated. Okay. Please wait. An order dated 18/11/2017. Address pending is 18.
Yes, Lordship.
Why wasn't it disposed of earlier? Is the 2017 passed by the Deputy Commissioner. Comma. Dimapur is the subject matter of challenge in this petition instituted under Article 226 of the Constitution of India. Full stop. By the said order, comma, while declaring the possession of the private respondent number 4 over the land in question, comma, the Deputy Commissioner had also made certain observations with regard to the ownership of the land. Full stop. Please have your seat. Para. The facts projected in the petition is that in the year 1984, a proposal was made for settlement of lands to various persons, including the father of the petitioner. Full stop. Pursuant to the said proposal, comma, an allotment order was issued on 18/12/1985 in favor of the father of the petitioner, allotting 1 katha, 5 lachas of land. Full stop. The said allotment order had, however, 7 numbers of conditions, including the condition to take over possession within 6 months. 6 months? Was it 6 months?
6 months, Lord.
6 months. Full stop. It is averred that on fulfillment of all the conditions, comma, the possession was taken over by the father. Full stop. The father of the petitioner, comma, in his lifetime had executed a gift deed in favor of the petitioner. And on his passing away, comma, the Jamabandi was issued in the name of the petitioner in the year 2015. Full stop. The payment of land revenue has also been done by the petitioner. And in this regard, comma, revenue receipt have been annexed in this petition. Full stop. Sarah? Since the petitioner had detected that some activities were carried out in the land, on the land, by unknown persons, comma, he had submitted an application to the Deputy Commissioner on 29/2/2016. However, no action was taken on the said representation. On the other hand, comma, the respondent number 4 had also submitted an application on 22/7/2016 claiming ownership with a statement that the petitioner had came to the land in June 2016. The Deputy Commissioner, by the initial order dated 27/7/2016, had passed a temporary order of restraint on the land in question, followed by show cause notices dated 19/12/2016. Full stop. On receiving the response from the rival parties, comma, the matter was considered, leading to passing of the impugned order dated 18/11/2017. Full stop. By the said order, the Deputy Commissioner had come to a finding that the as per number 4 had purchased the suit land, and there is no doubt with regard to the ownership over the suit land. Full stop. Para. Ms. B. Sharma, learned counsel. No, I heard Ms. B. Sharma, learned counsel for the petitioner. Full stop. I have also heard Ms. Sunso, London State Council, whereas the response number 4 is represented by Ms. Sunso, London Council. Full stop. Para. The learned counsel for the petitioner has submitted that the father of the petitioner was duly allotted the land in question by the order dated 18/12/85, pursuant to which he had taken possession. Full stop. In this regard, the pleadings made in paragraph 8 have been pressed into service. Full stop. It is also contended that upon gifting the land to the petitioner by his father out of natural love and affection, the name of the petitioner was duly mutated and Jamabandi was accordingly issued in the year 2015. Full stop. The London Council has also drawn the attention of this court to the revenue receipts to claim that the land revenue were duly paid by the petitioner. Full stop. It is contended that while the petitioner had approached the Deputy Commissioner on 29/2/2016, no action was taken, whereas the application filed by the respondent 4 later on 22/7/2016, cognizance was taken. Full stop. The Learned Counsel for the petitioner has assailed the order dated 18/11/2017 by on the grounds that apart from a wrong appreciation and error appreciation of the materials on record, leading to a perverse finding, the observations made on the aspect of the ownership of the land is wholly beyond the jurisdiction of the Deputy Commissioner. Para. Thus, so London State Council, on the other hand, has submitted that a bare reading of the order dated 18/11/2017 would indicate that the order is a reasoned one, which has been passed by taking into consideration all the relevant factors into consideration. It is submitted that the conditions of the allotment order dated 18/12/1985 were also taken into consideration, and a finding was arrived at with regard to condition number 1 and condition number 7. Para. The learned counsel for the response number 4, while endorsing and supporting the views expressed by the learned state council, has strenuously argued that the that though the allotment order was in favor of the father of the petitioner, comma, he had never fulfilled the conditions, comma, more specifically, condition number 1. He has submitted that the land was not taken possession within the stipulated time, and the same would also be evident from the application of the petitioner dated 29 to 2016. It is submitted that the respondent number 4 had duly purchased the land from the lawful owner, and because of the present restraint order, comma, the construction is at a halt. Full stop. He accordingly submits that the writ petition should be dismissed and the interim order be vacated. Full stop. As regards the issue of the jurisdiction of the deputy commissioner to pass orders on the aspect of ownership, comma, the learned counsel has submitted that such observation is permissible as it is based on the materials on record. The rival submissions have been duly considered. The allotment order dated 18/12/1985 in favor of the land, in favor of the father of the petitioner, is not in dispute, and neither the said allotment order has been the subject matter of challenge in any earlier proceeding. The petitioner name, the name of the petitioner has also been mutated, and Jamabandi issued in his name in the year 2015, which presupposes that a verification of the possession of the petitioner was made. Full stop. The revenue receipts pertaining to payment of land revenue have also been produced. Full stop. In view of the above, comma, this court is of the opinion that the petitioner has materials to show and contest the aspect of possession. Full stop. On the other hand, comma, the respondent number 4 in his affidavit in opposition has also made categorical statement of purchase of the land in question by a registered deed from the lawful vendor. Full stop. There are, however, certain materials placed on record in the writ petition regarding the respondent number 4 possessing excess land. Full stop. Be that as it may, comma, the exercise to be carried out, which has been carried out by the Deputy Commissioner Dimapur, is akin to
Mr. Moxie, before it's not in the excess position of the land.
that is their suggestion. We have not. This is not your prayer. This is what is akin to a proceeding under section 145 of the CRPC. Full stop. The jurisdiction and power of the deputy commissioner in a proceeding of such nature is only to make suitable directions and order regarding the possession only, and the said power cannot be extended to decide the question of ownership, which is strictly within the ambit of a civil court. Full stop. Para. There are materials placed on record from both the rival parties claiming possession as well as ownership. Full stop. This court, in exercise of powers under Article 226, cannot go into the factual aspects. Full stop. However, it clearly appears that in the impugned order dated 18/11/2017, the Deputy Commissioner, Dimapur, has exceeded his jurisdiction in making observation on the aspect of ownership of the suit land. Para. In view of the above, the said order is not sustainable in law and is accordingly set aside. Full stop. Para. However, the question of ownership being a disputed question between the petitioner and the respondent of 4, this court gives liberty to either of the parties to approach the appropriate civil court for a suitable declaration on the aforesaid aspect. Full stop. The aspect for which a maximum period of a month is given. Full stop. The parties may also pray for any temporary injunction regarding the possession aspect. Full stop. Since this court, while entertaining this petition, have passed an interim order which is operating, it is observed that till this period of a month, the said interim order would be in operation, whereafter the aspect of injunction would be considered and decided by the appropriate civil court in accordance with law. The requisition accordingly stands disposed of.
Lordship, it is a 1 month time. Civil court of approach.
Yes,
It helps to approach.
we have said only 1 month. Interim order will be vacated.
Lordship.
We've said.
Yeah, because I have to talk to my client.
No, we have made it clear, very clear.
That's very specific.
We have made it very specific. Read the order, very specific.
For hearing item number 24 to 26. Item number 24 to 26.
Yes,
Yes,
24 to 26. Yes, please.
also here. I'm praying for regularization of my service for pensionary benefit. And as well as I'm challenging the office memorandum 17/3/2015. Clause 1, subclause 1 and 2. This is the second round of litigation. The text of the case in brief is that the petitioners they were appointed
Yes.
by order dated 2/5/1985.
Yes.
Which is in my annexure A, page 15. Worship, that is in WPC number 53 of 2022. Annexure A, page 1518. With the post of work charge fixed level under the establishment of STO, PWD water and bridge.
What are the grounds of challenge? What are you challenging? The office notification.
Lordship, here I'm praying for regularization of my service, the pensionary benefit. And before I was released from the service, I've submitted, while I was in service, I've submitted a representation several times to the department.
How many years did you serve?
For 35 years.
35 years in
Yeah.
scale payment.
On fix.
Fix.
Yes. So I've submitted several representation
Yes.
while I was in service to grant me at least scale of pay. However, the respondent of the team has not granted me scale of pay and even for regularization, I have submitted a representation. So in agree, I filed WPC number 28 and 36 of 2020. And by this honorable court, I have directed the state respondent to grant me minimum scale of pay and to regularize my service as per the office memorandum 73/2015 for pensionary benefit. However, while I was in service, rather they have issued impugn letter stating that since I was fixed pay salary and as per the office memorandum 73/2015, only those government employees who are enjoying scale of pay and after serving for 30 years in service, the service are going to be regularized. So the government stands that since I'm on fixed,
Yes.
so my case cannot be considered. In agree, I'm also challenging the office memorandum 17/15 on the ground that this office memorandum is arbitrary, discriminatory, and in violation of Article 1981.
Yes, madam. There are cases where earlier also 17/3/15 was put to challenge. What had happened to those cases?
Regarding this, there are still some of them are pending, Your Lordship, pending for disposals, Your Lordship, because the pleadings have not been
See,
completed.
OM says of 17/3/15 that if you serve for more than 30
Yes,
years
Your Lordship, yes.
in scale pay,
Yes,
you would be given the benefit of
Yes,
regularization.
yes, Lordship.
Now he was serving in fixed pay,
Yes, Lordship.
but he fulfills the other criteria of 30 years.
Yes,
He
Lordship.
says he's more than 35, almost 35
Yes,
years.
yes.
But the one part he is not fulfilling
Yes.
regarding the pay.
Still pay, yes.
So
Lordship.
he's putting to challenge this 17/3/15.
Yes, Lordship.
Now 17/3/15 is also the subject matter of challenge in other petitions. What has happened there?
Lordship,
This OM of 17/3/2015,
yes.
has it been challenged
In
earlier?
Yes, 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 Lordship. And
When are those
petitions-
cases coming?
Those are still pending, Your Lordship. But in this present case, Your Lordship, the petitioner is not covered by the OM, Your Lordship. He is
No.
covered by the OM 2004 because he is a fixed pay employee, work charge. So he is covered by the OM 2004.
50%.
50%. And he can be regularized provided he is the senior most, Your Lordship.
You are still in service.
He is already retired, Your Lordship. So now he cannot challenge the OM 2015.
When did you retire?
In 2020. Your Lordship.
Before filing this?
Yes, Your Lordship,
Yes, we
yes.
filing this.
See, there are two, madam is correct, absolutely. There are two OM which are running together
Yes,
and both are on different footings. One gives you the scope of being regularized on 50% quota of the vacancy arising in 1 year.
yes, Your Lordship.
And the other is that if you are in scale pay for 30 years, you become automatically regularized. So your avenue or scope of being regularized only because you are in fixed pay is not totally shut down. You still have an opportunity on 50% of the vacancy. And it depends on the seniority.
Yes, Your Lordship, yes.
Here in my case, there's no government policy.
No, that is, so,
Even my junior, they now also they are doing scale. Many of those workers employees. So now, after serving booking service for 35 years, I mean, service on this. So here, the government here shows discriminating because this two pick and choose policy. They used to grant scale of pay to some employees who are much more junior to them. And to some, even after serving for 35 years in service, their service, they were not granted scale of pay. And as a result of which, by this OA, they don't fall under this OA and they were released from the service without any pension. My case is fully covered by with April 35 of 2022 last time. So, with April 35. Past this year.
Yes,
on the
this
month of
appeal,
February.
we had already filed an SLP, Your Lordship, in the Supreme Court, but because of the holiday, it could not be disturbed. Your Lordship. This one cannot cover this because it's a, actually, this country.
Similar methodology. Takes, they also the petitioner, they responded, they were on fix. They were released from the service. Not this OM. They were also not rest. As far as the service were not regularized. However, the legislative failed given a direction to regularize the service. And the student applicated they filed with the and it was dismissed.
this was an appeal.
Yes.
In this case, the learned single judge, he has directed the state to regularize the petitioner, Your Lordship, because petitioner is a fixed pay employee. He does not come within the provisions of the purview of OM 2004 because he stands at serial number 9 in the seniority list. So we challenge that single judge judgment before the division bench, but the division bench has dismissed our appeal. So, Your Lordship, in order to be regularized, a person has to come within the policy of the government. He does not come within the policy. So if we give regularization to this person, he will be superseding 8 of his seniors who were not regularized. So we have already filed an SOP.
But those aspects were taken into consideration by both the learned single judge and the revision bench. Your filing of appeal, further appeal, that's a relevant aspect, but unless there's a stay order,
Yes, Your Lordship. That's true. But Your Lordship, if we see the order, Your Lordship, in order to be regularized, there has to be a.
when did you prefer this appeal before this Honorable
SO
Supreme Court?
This year, Your Lordship, this year.
When was it? Before the vacations?
Before the vacation, Your Lordship, yes.
Okay, so for all fairness, let's wait for some time, a month. But unless you can place an order of stay, because this is
Yes,
affirmed,
yes.
affirmed by a division bench.
Yes,
You have to
affirmed by
follow the
the
division bench.
Yes, yes, yes.
Merely filing of an appeal may not be a good ground
True, true, Your
or
Lordship.
good enough ground. Okay.
Because, Your Lordship, because earlier
Okay,
also.
okay. In this bunch of writ petitions, comma, the petitioners are claiming pensionary benefits, post pensionary benefits, first number benefits, which are further, look like this. In this bunch of writ petitions, come on, the petitioners have claimed for regularization of their service and a consequent order for payment of post-retirement benefits. The petitioners have also put to challenge an office memorandum dated 17/3/2015, whereby the benefit of regularization has been restricted only to those set of employees who were getting scale pay. First off, it is submitted that though the petitioners were given fixed pay, it was not within their ambit, and the state respondents could not have discriminated in making the payments. The learned counsel for the petitioner has also submitted that the issue has been decided by this court, which has been affirmed by the division bench by judgment and order dated 6/2/2024, passed in WA 35 of 2022. The London State Council has, however, informed this court that the aforesaid judgment has been put to challenge before the Honorable Supreme Court by way of an SLP, which is likely to be listed after the summer vacations. In view of the aforesaid facts and circumstances, the matters are adjourned for a period of 6 weeks. However, on the next date, the London State Council is to apprise on the orders that may be passed in the appeal referred by the state. Detective, thank you. Present on the next date.
Hearing item number 29. Item number 29.
Yes, madam.
So, Lordship, my senior has some personal difficulties today, Lordship, so I
Who
pray
is
that
this in your?
I am to Lordship.
Yes, who's there on the state? Yes, grant some time next week
Yes, Lordship, after you.
on a. No, it is submitted that the learned council conducting the case is having some personal difficulty today, and therefore adjournment is sought for list after a week.
Lordship.
For hearing item number 30. Item number 30.
3-0. Please.
This is short matter. It pertains to commercial appointment.
Yes. Anything?
I'm ready, however, Your Lordship, but the private respondent is absent. Lordship.
Who's for the private respondent? Name is shown in the cause list.
Yes, Lordship.
Is it there in the bar? Is she there in the bar or not there today?
It is shown.
Is she there in the bar today? Have you seen her in the bar today?
No, Lordship.
Is she aware?
Cause list is already out, Lordship. This is long pending case. Short matter.
We give her a chance. We'll have it on Monday. But if he doesn't appear, we'll have it on Monday.
Thursday, day after. Lordship.
Day after. Okay, we can try day after tomorrow also. So the learned counsel for the petitioner, as well as the learned state council, are present. The learned counsel for the private respondent number so and so, she will give. He is not available. Do seven is not available when the matter is called up, in spite of names being reflected, name, not names, name one, being reflected in the cause list. Peter, is it name, comma? Peter is name, and in the interest of justice, let a further opportunity be granted, and the matter be listed day after tomorrow. Published.
For admission, item number 34. Item number 34.
Yes.
May I please, Your Lordship.
Lordship, in this particular case, several attempts has been made to dispose of the matter because certain agencies involved in this case. Lordship, now the petitioners are all retired. And in the last occasion,
We have seen this. We have seen the order.
yes, Lordship. And in last occasions, I'm asked to address the court whether, since I have filed this petition during the time of my service and now retired, so whether by the present in the present form, whether the proceeding can proceed, that is an issue. Lordship, may I take the Lordship to the order? Lordship, may I draw your attention to the order passed by this board? Lordship, order dated 10/8/2023.
10/8/23.
Yes, Lordship. Because this is a matter pending from 2020. A few orders. Because see, I was about to retire. So I was pressing the court to dispose of the matter.
10/8, yes.
Yes, Lordship. Married Lordship. Mr. So-and-so senior government advocate shall on the next date come with the instruction as to what steps have been taken to consider the promotions of the petitioners to the next higher post, which, as submitted by the petitioner, are lying vacant. This is the first order, Lord, not first order. This is one order. Then thereafter, Lordship. Order dated 22/8/2023, Lordship.
Dated 20?
22/8/2023.
Yes.
Because I was retiring on 31st/8/2023, Lordship. So this is just before retirement. Lordship, the last subpara of the first page, it is submitted by the learned counsel for the petitioners that the petitioners are due to retire on 31st/8/2023, for which the learned counsel for the petitioner expresses urgency in the matter. The learned senior government advocate submits that even if the petitioners retire during the pendency of the present petition, the petitioners would be entitled to be promoted with all consequential benefit. Then, Lordship, having considered the submissions of the learned counsel for the parties, list this matter on so and so, on which date the learned senior government advocate shall obtain and place the concrete instructions without fee. So, Lordship, then thereafter, one more order, Lordship. Order dated 21st/9/2023. Now, this is after retirement.
Order dated?
Order dated 21/9/2023. Lordship, the relevant portion would be the second last subpara. The learned senior government advocate, Lordship. Second last para.
Yes, yes.
The learned senior government advocate shall file affidavit clearly stating the intent of the government as brought out in the letter dated 11/8/2023 and 22/8/2023. The affidavit shall file within a period of 3 weeks. Mr. Kekringle, learned counsel for the petitioners, submits that by the release order dated 14/9/2023, the petitioner has been released from service without any promotion. So, Lordship, one after another. Lordship, one more. Finally, 16/10/2023. 16/10/2023.
Yes, yes, yes.
Yes, Lordship. Mr. Lordship.
Yes, yes.
Yes. Mr. Anangami, the learned senior government advocate, submits that the government is actively considering to give retrospective promotion to the petitioners already retired from service by holding the DPC, and therefore seeks for 3 weeks' time for allowing the government to complete the process.
Yes.
So, Lordship, one after another. And the prayer I have made is also very simple logic. My case is that in the year 2020, I was given promotion and the promotion on 9/6/2020, I was given the promotion.
Yes.
Considering the policy adopted by the department for the promotion, then also having the sufficient vacancy that also available in the department. So soon after, my promotion order was issued. After a month, Lordship, the state government, the secretary to the government of Nagaland had written a letter to the principal director stating that since there is a proposal for the upgradation of certain supervisors to the higher post, that is special grade. That proposal is pending, for which my promotions to put on hold. That was the letter. And since then, no promotion has been made and my promotion has not been affected. And till today, it is withholding. So during the pendency of the case, I was made to retire because on completions of 35 years. That is one point. And Lordship also not only that, but several statement has been placed before this court, stating that even if I retire, then still then, the retrospective effect, that all the consequential benefit that I am entitled for will be given to me. So Lordship, for that matter, and my prayer is that just to quash and set aside the letter that by which my promotion order has been put on, withholding my promotion, to remove that and to take effect of my promotion order. This is my prayer, Lordship.
But the order of 8/7/2020, it gives the reason that cabinet approval was not taken prior to issuance of 9/6/2020. Without a cabinet approval, can 9/6/2020 could have been issued?
That also issued in respect of other group of supervisors, Lordship. That also already considered.
No, see, the order which is against you
is
dated 8/7/2020.
Yes,
correct?
Yes.
Did that the earlier order of promotion was put to hold only because of lack of cabinet approval?
Yes, sir.
Can you say that this reason which has been cited is not a good reason?
No, that can be Lordship. That is in respect of the other group, but of course that also in the line of the supervisors.
Yes.
I'm also promoting to the supervisor. And that supervisors, a group of supervisors, which is also now, since for the upgradation, cabinet decision was necessary. And the cabinet decisions was taken on 13/6/2022. 13/6/2022, Lordship.
13/6/2022.
Yes, Lordship. The cabinet decision. Lordship, may I take your Lordship to the effects of the case?
13/6/2022, and he had retired in August 23.
Lordship.
So they had almost 1 year to give effect to the promotion or upgradation.
Yes, 2022.
Yes.
That is in respect of other group of people, not in respect of the petitions.
So not in respect. So
For
you, was there any cabinet approval before you retired?
Not necessary, because I'm just for the regular promotion only, Lordship. So cabinet decision is not necessary in my case. This is my case. Yes. That is in respect of some other group of people. Whereas because of that, even my promotion was put on hold. So I'm saying that That too has been considered by now. Why not remove the letter by which the impugn order, by which my promotion has been put on hold? So I'm not asking for ever.
What were you, what was the federal post you were holding and what was the post you were aspiring to become?
Lordship, presently I'm the female health worker, grade 1.
Female health
Workers, grade 1.
FHW,
Yes, Lordship.
grade 1.
Yes.
And you aspire to become what?
To become female health workers supervisors.
Female health
worker supervisor. So in short, supervisor. The Lordship, that the cabinet decision.
But the order of 9/6/2020, by which grade 1 female health worker were promoted to the post of supervisors, that was put to hold only on the aspect of cabinet approval. You are saying that yours is a regular promotion, for which cabinet approval may not be necessary. So aren't you aspiring to become from a grade 1 worker to a supervisor?
Lordship.
That is a regular, why was the aspect of cabinet approval that's given in the order dated 8/7/2020?
That if I'm also subsequently after promotion, my promotion to the supervisor, if I'm entitled for, then I will be given to that higher post again. Further promotion will be given. So my same grade, I was appointed in the year 1988. I was initially appointed in the year.
We'll come back at US. What do you say?
Lordship.
What do you say?
Yes.
Lordship, in fact, the cabinet decision that was given was not only meant for the petitioner, but for the person who was senior to the petitioners.
So there were other persons senior to them.
Yes, yes. Now promotion was given not only to the petitioners, but to the seniors of the petitioners also by a same date, but different orders.
9/6/2020.
Yes, yes, yes. Yes, Your Lordship. However, that promotions was not affected through the cabinet decision.
Okay.
And therefore, the promotion that was given by that order 9/6/2022 was put on hold, waiting for the cabinet
But your
approval.
colleague is saying that for this kind of promotion,
Yes,
the cabinet approval may not be necessary.
Lordship, their seniors were promoted, and in the post that was vacated by the seniors, the petitioners was promoted there. So
that is the issue.
So, Your Lordship, if the seniors promotions was put on hold, that means they reverted back to the original position. There's no vacancy left for the petitioners to be promoted.
No, at that time, 2020,
Lordship,
the petitioners were holding what post?
grade 1.
Grade 1.
Grade 1. And their seniors were holding supervisor.
The supervisor's promotion to the higher post,
special grade.
That was not with cabinet approval.
Yes, that was not done by
So
cabinet approval. They was reverted back. The promotion was put on hold. That is the issue, my lord.
That was the.
We'll come back.
Yes, Lordship, Lordship. Very interesting, Lordship. Well, instruction as well. USC submitting. Petition can be right. Yeah. Now let's see, we were wondering, normally motions come to us. What? Motion come to table, then admission be on regular day. Then once it's covered, reaches to the order, then admissions come to our order. Go ahead, my order, yeah. Order of the regular, we go. Normally. Before. What is your number? Once you cover it. Lordship, if I'm claiming my promotion, which is against the vacancy caused by my seniors, who have been, the posts have been upgraded to the senior grade, special grade, then I don't have any case. In that case, I don't have any case. But my case is that since there is a vacancy, I have filed the vacancy list also. And I'm the senior most in that zone of considerations for promotion. And every year promotion has been given to the grade 1 female health workers. Just to my turn, that has been put on hold, for which I'm saying that no, my fundamental right has been violated. Watch it. Lordship, coming to the next, my petition. Page 15th.
50?
This is my appointment order.
50?
Page 15th of my read petition.
15?
15th. This is my appointment order.
Yes.
So, Lordship, this is my appointment order. My name is in serial number 7, 8. Lordship, do I need to? Because only 16th petitioners here.
This is dated?
Dated in the last, dated 11/8/1988. 11/8.
Appointment order.
Appointment order.
How many of you are there? 16?
I'm only 16 of us only, Lordship.
Okay.
Yes. But see, all of us, we were appointed by this board.
Okay.
Yes.
Appointed as?
Appointed as female health workers. Or in other words, again, auxiliaries nurse midwife. Or also they're called as auxiliary nurse assistant. That is the three, but all these are equivalent. Lordship, then by page 20, this is the type copy. The original order is in page 19. Okay. A service rules for the nursing also there. Whereas there is no promotional scope for the female health workers. So the government has adopted a policy. Lordship, page 20 is a type copy by which the female health workers, the promotional avenue scope has been made by way of policy. So 50% will remain as female health workers assistant, 50%. Female health assistant 1, that is grade 1, Lordship. Now I'm talking about. This is 30%. I'm in that category right now. Then next promotion is female health supervisors. That is 20%, Lordship.
Yes.
Yes. On the basis of it, Lordship, on the basis of the policy, and it is not a disputed by the respondent also. Lordship, by 21, page 21. I was given the promotion, first promotion, Lordship, by 2006. This is order dated. Lordship, my order dated 28/3/2006. Yes, 28. By this order, I was given promotion to the post of female health workers grade 1. So that was the only promotion I got in my throughout my service career. Lordship, my name is there, but it's not necessary I'm included. Lordship, just for quite reference, my name started from serial number 88 because there were some seniors.
Yes.
So 88 from 88, and in between some have been left out till 117.
Okay.
Yes, Lordship. Then Lordship, the promotions, that was the, earlier it was just upgradation. Upgradation in the sense from female health workers to female health worker grade 1 was just upgradation. But Lordship, later on, they have named as promotion, treated as promotion. Lordship, what happened by then, this page 29, this is my order. Since 2006, no promotion. Then Lordship, page 29.
Yes.
Yes. By
96.
this order,
96.
96, Lordship. By this order, 27 of us, we were given promotion to the post of supervisor. That also, Lordship, as per the approval, that is with the prior approval of the PNR department, and also the concurrence of the finance department, Lordship. That is there in the order. So while Lordship, while the promotion, that when I'm talking about the promotion, I was later on, I found out the vacancy list.
Yes.
Lordship, I found a vacancy list.
Yes.
Lordship, I filed one affidavit in reply. Lordship, I filed one affidavit in reply to the compliance affidavit filed by the respondent number 1, 2, 3, and 4. Therein, I filed one vacancy list, page 6. Page 6.
Yes.
There were, by the time when I was given promotion, 2020, there were 27 vacancies, Lordship. 27 vacancies. Lordship, serial number 1 till 27, Lordship. Going by the retirement and the completions of 35 years, Lordship. These are the vacancies I've obtained from the office later on. Lordship, I did not, in this affidavit, I did not file the release order of each and every
Doesn't
person.
matter.
Yes, I have all the list with me. So, Lordship, there were vacancies in the year 2020. Thereafter, after my promotion. So, different questions. Lordship, so by 2000, by 9 June 2020.
This is the, this should be a as and when vacancies.
Vacancies, Lordship. Vacancies that you will find, Lordship will find. In the last column, Lordship will find lease of release order on completions of 35 years of service from Health and Family Welfare Department. So the supervisors, designations, supervisors who have retired.
No, that we have understood.
Yes.
This contains a list of 38 persons.
38%.
38, and their dates of retirement or completion of 35 years, you have also indicated in the last column.
Yes.
So why are you restricting to 27 only? It's got 38 numbers.
No, but see, these are retiring after my promotion order only. So what I'm trying to show is that vacancy by the time when my promotion order was issued, these 27
Yes.
have already retired. So I'm against those vacancies, Lordship.
27.
Yes.
No, your promotion order was dated 9/6.
9/6, Lordship.
So the 27th person is retiring on 36.
Yes. Then 26, Lordship.
After 26.
26. Lordship, one person who expired.
But doesn't matter, you are 18.
Yes,
You are 18
against
only.
the vacancy.
You are 18 only.
Yes.
So it will anyway cover 26.
Yes, Lordship. 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 So Lordship, then what happened? Impugn order, page 31. When I was very happy, after a long gap, I was given promotion. Page 31, Lordship. What happened?
Yes.
This is a letter issued by the Secretary to the Government of Nagaland to the Principal Director. Not only in respect of my order, Lordship, in respect of so many orders they have mentioned. I do not know about others. Because 3 orders are purportedly issued on 9 June 2020, Lordship. So it's my order also included here. But for the reason, Lordship, the subject itself, upgradation of 20 persons of female health workers supervisors to female health workers special grade, Lordship. So in order to create promotional avenue to the female health workers, career progression, Lordship, this was proposed, and the proposal, it's mentioned proposed. So a proposal was placed for some promotional avenue in respect of some 27 persons. What it was only on 8 July 2022. This is the area, Lordship. So since they were mentioning upgradations of 20% female health worker supervisor post to female health worker special grade, I was also anticipating that, okay, I was promoted to the supervisors against some vacancies. Whereas I was also anticipating that if once the posts of supervisors are upgraded, okay, not promotion, upgraded to the post of the special grade, that I was also anticipating to get it. So I was waiting for it, Lordship. I'll show the Lordship the cabinet decisions later. Then Lordship, after that, waiting for about 3 years, Lordship, thinking that, okay, my promotion order will be affected. My Lordship, page 32. Page 32. I found out that later on, by 27 March 2023, yes, 26 of them have been, the 26 post of supervisor have been upgraded to the post of special grade, Lordship. Special grade. This is page 32, Lordship. With the cabinet, with the approval of the cabinet. Amongst the 26, Lordship, I wanted to draw your attention from serial number 9, who has also upgraded to the post of special grade. From serial number till 26, they are of 1988 batch, my same batch. Date of joining, Lordship. From serial number 9. But Lordship, I'm not disputing their promotion, upgradations, whatever. Just to show that even that for one reason, my promotion order has been withheld. So for that reason, I'm showing that, see, even that too has been considered. That is the reasons why I have enclosed the order. Lordship, since there have been without several commitment has been made, but since I'm about to retire, so Lordship, on page 35, on 10/5/2023, I have submitted my representation because I'm due to retire on August 31st. No action has taken, so I had no other option. I submitted a representation on 10/5/2023. despite of which, no action for which the present writ petition has been filed. Lordship, I wanted to show the actions of the state government. Every year since the adoptions of the policy, starting from 2006 till 2016, Lordship, from 2006 to 2016, every year promotion has been given to the grade 1, the female health worker grade 1. I'm going to show it here. Yes. Every year, almost every year, except in 2 years, because there was no vacancies, I suppose. But whenever vacancy arose, against those vacancies, promotions were considered. Lordship, may I take the Lordship, since the hearing date was fixed, so earlier I filed one IA in order to incorporate one document.
Doesn't matter.
Yes, Lordship. Okay. Lordship, may I show in the IA? IA
No,
61.
that is okay. We have taken into account that from 2006 to 2016,
Yes.
except 1 or 2 years, in every year, there were promotions regularly done.
Lordship. And see, as many as more than 100 have been promoted to the
We
post.
may not be required to go into those aspects. What we have understood from you is that your claim is from promotion to the post of supervisor to the special grade. Special grade.
From special grade.
No,
from grade 1 to supervisor.
No, from grade 1 to supervisor, you want to, sorry, from grade 1 to supervisor, which you were already given, and your promotions were withheld because those persons who were promoted from supervisor to special grade, it was not approved by the cabinet. It was not approved by the cabinet.
Yes.
Now you have shown a clear vacancy position that as on the date of your promotion to the post of supervisor, irrespective of the fact that certain promotions were made to the post of special grade, vacancies were existing. That is your basic.
That is my basic.
Yes.
Yes. Yes.
As far as the vacancy is concerned, vacancies, the petitioners that placing the vacancies are cast due to retirement.
Yes.
Now, the petitioners are here categorically mentioning at paragraph 14 in the writ petition. If I may be allowed to read it.
14.
14.
Yes.
May I read, madam?
1-4.
1-4, page 11 of the writ petition.
Yes, please.
Lordship, that it is respectfully submitted that the promotion of the petitioner to the post of female health worker supervisors are against clear vacancies caused by the previous female health workers who were promoted to the higher post. So their promotion is cast because their superiors were promoted to a higher post that is special grade. What vacancies was there, your lordship, at that point of time is not relevant as far as this writ petition is concerned. Because here is a case, your lordship, where not only the petitioners, but the petitioner's senior's promotion was also affected. And because the petitioner's senior's promotion was affected, the vacancy that arose because of that promotion, the petitioners was accommodated and promoted there. But because the cabinet has not given its approval, and therefore the promotions that was affected, given effect to the seniors as well as to the petitioners, was put on hold. That is the issue, your lordship. What vacancies arose?
Mr. Government Counsel.
Lordship.
See, their understanding in which vacancies they were promoted, that will not be the sole factor. They do not know which huge vacancy. They are
Yes.
interested in their promotion.
Yes.
It is up to you
Yes.
to clarify
Yes.
to the court that their promotions were against vacancies which were due to promotion.
Yes.
Or vacancies which are existing because of retirement of the senior incumbent.
Yes,
Because their outlook is not on which vacancy. They want a resultant vacancy. It may be a vacancy due to promotion of the incumbent or due
Yes.
to retirement of an incumbent.
yes, yes,
Now, they have shown a list where, so far as the numbers of petitioners are concerned,
correct.
there were such numbers of vacancies which would arise in because of retirement.
Yes.
Now, where do have those vacancies gone?
No, your lordship. Those vacancies are not the subject matter as far as this writ petition is
No, no,
concerned.
where the vacancies, did you abolish those posts? You did not.
No, no.
So where did those vacancies go?
Your lordship, that vacancy, whatever the vacancy is there as of today,
Yes.
is not an issue in this writ petition. The issue is promotion to the petitioners and what date it should be effective.
Yes.
That is the issue, your lordship. That is the issue. Not how many vacancies are there, where the petitioners will be accommodated. That is not the issue,
Mr. Council, there may be a misconception on your part.
lordship.
We are examining an order of promotion
Yes,
followed by an order by
Yes.
which
yes,
these promotions were put to hold
yes,
as a consequence of lack of cabinet approval to another set of persons who
Yes.
were promoted to a higher post,
correct, correct,
namely the special grade.
correct, madam.
Special grade did not have the cabinet approval, so you put on hold. Automatically, you said that the earlier promotions of the lower grades to the post of supervisors will also be put on hold.
Yes,
Now, their promotions we have seen
Yes.
had the recommendation of the APAR,
Yes.
had the concurrence of the finance department.
yes,
We are not too much bothered with what was the nature of the vacancy.
correct,
Now, will the order by
Yes.
which we have withheld
yes.
the promotions of supervisors to the rank of special grade
Correct.
should affect their promotion?
Lordship, in that case, allow me to take my lord. Since my lord has mentioned about the PNR as well as the finance department approval, allow me, your lordship. Your lordship may kindly come to page 29
Of the
of the writ petition, your
Okay.
lordship, annexure 5,
29.
page 29.
Yes, please.
Now, your lordship, I would like to refer to the second para that starts with as per the approval. May I read? Madam?
Yes, please.
As per the approval, PNR Department wide your number 687 dated 26/10/2018
Yes.
and concurred by the Finance Department via RFC number 35/5 dated 6/11/2000. So
Yes.
this is the finance as well as the PNR approval number.
Correct.
Your lordship may kindly come to page 32.
Free to.
Yes.
Yes, please.
Page 29 is the order where the petitioners was given the promotion.
Correct.
Page 32 is the order where the petitioner seniors promotions was affected. I would like to read the second para again, your lordship. Starting with, this is in pursuance, madam.
Yes.
May I read, madam?
Yes.
This is in pursuance to the approval of the cabinet number such as 2013 dated 14/6/2022. PNR Department wide your number 687 dated 26/10/2018 and concurred by Finance Department RF Establishment 3556. So the Finance Department and the PNR Department actually has together approved the approval of the given the approval of the promotions to the petitioners as well as to the seniors of the petitioners. Now, if that approval is put on,
Just a minute, please.
PNR 687, your lordship, dated 26/10/2018.
Now the cabinet, the issue
Yes, ma'am.
of cabinet approval
Yes, ma'am.
is only with regard to the upgradation,
Yes,
not for regular promotion.
yes,
Upgradation is from the post of supervisor to special grade,
yes, ma'am.
which the petitioners are not connected.
No,
Petitioners are connected with a regular process of promotion from grade 1 to supervisor.
yes,
For that, cabinet approval is not necessary.
yes. If it is a regular promotion,
Yes,
it is not
not
necessary.
necessary.
But it is a promotion caused due to the promotion of his seniors. This is what the petitioners admitted in the petition
No,
at
that
paragraph
is-
14.
That is what we have clarified to you,
Yeah.
their understanding will not have any effect on the matter.
Your Lordship, they
They-
themselves knows and they're admitting it in their own writ petition.
No, it is your official records. Will they say that, no, no, I was promoted again a dead vacancy? It turns out to be not a dead vacancy.
Yes.
Will their case go? Not at all.
Your
It is
Lordship,
not within their domain or knowledge.
Yes.
In which vacancy? They are interested in their promotion.
Yes.
What is the vacancy you have to clarify to the court?
yes. Then in that case, Your Lordship, vacancy was cast maybe at that point of time. Maybe at 2020. Say for instance, Your Lordship. Cast at 2020. Petitioners was not given promotion at that point of time. Now, Your Lordship, can retrospective promotion be given in
No,
that case?
it's not a question of retrospective promotion. Their promotion is dated 9/6/2020.
Yes,
Now we tell the promotion in the year 2020. When? When was the withheld?
promotion to 28 July 2020.
2020, just immediately after the promotional order.
Yes,
The withholding order was there on
on 8th of July 2020. Your
8
Lordship,
July 2020.
yes,
Now, now they had retired not as supervisors, they had retired as grade 1. But their claim is that they would have been promoted, should have been promoted
Should
to
have been.
supervisors.
yes,
Now they have retired.
yes,
So the question of giving them benefit, actual benefit, as working as supervisor may not arise.
yes.
But what about their post-retirement benefits?
Yes, Your Lordship, as far as that part is concerned, that is why I'm saying, Your Lordship, the petitioner, if at all they feel that there have been aggrieved and the promotions was supposed to be cast by 2020, when these promotions was put on hold by 8th of July 2020,
Yes.
they have never come and approached this court challenging this.
When was this writ filed?
Your Lordship, the writ was filed. And not only that, Your Lordship.
But at least from 27/3/2023, when the upgradation order was given concurrence by the cabinet,
Yes.
but thereafter, why didn't you promote them?
No, Your Lordship. That is why we are in fact in our affidavit in opposition, Your Lordship, we have annexed document. The government, the department actually decided to promote them with effect from the date that the cabinet give its approval to his senior, that is 13/6/2022. We have decided, Your Lordship. We have decided, and with that decision, Your Lordship, their case was placed before the DPC. However, because there is an office memorandum issued by the PNR department, wherein retrospective promotions cannot be affected through a DPC, and therefore DPC could not take a decision. Otherwise, Your Lordship, in our affidavit, as well as the letters that have annexed in our affidavit, Your Lordship, we have the intention of promoting them exactly on the date where the seniors were promoted. That is on the date that the cabinet has given its approval. Your Lordship. And that answers the first prayers of the petitioner, Your Lordship. Because Your Lordship, as my learned friend has rightly said, he has a very limited prayer here. Second prayer is to give promotion from the date of, from retrospectively from 9/6/2020. That's where Your Lordship, the issue lies, Your Lordship. Now, whether this can be allowed or not, Your Lordship. Otherwise, as far as the promotion date of the petitioners, we have already, Your Lordship, we have already taken a decision that, subject to the approval of the government, that the petitions will be given promotion with retrospective effect from 13 6th, 2022.
Have you given effect to that decision?
No, your lordship, it has been placed before that is why, your lordship, to give effect to that,
No, the
we have
DP
even placed it before before the DPC.
No, DPC, you have, see, it's a futile exercise. If you know that there is an office memorandum, DPC cannot act. What is the requirement of placing it before an authority which cannot act? This is a useless exercise. You are the government. You are the authority.
Yes, yes.
DPC, everything works under you.
Correct, my lord.
If DPC is not empowered
Yes.
to give retrospective promotion, no
Yes.
need of, how can you place it before the DPC for a futile exercise?
Your lordship.
Take a decision,
Yes.
approve it.
So your lordship.
Authorities to support that.
So your lordship. In fact, when after the DPC declined,
Yes.
stating that DPC cannot give retrospective, the department have again written a letter to the government to
Okay.
consider the case of the petition, which is pending. Your lordship will find in my affidavit in opposition at the last page, your lordship, this was
How soon can you finalize?
lordship.
How soon can you finalize?
To dispose of this letter, my lord.
The entire proposal, see, after the decline of the DPC,
Yes.
matter has been again referred to the government.
Yes, yes.
Now,
By
how soon-
letter dated 7 March.
How,
2024.
within what tenure can the matter be finalized? Since on principle you have taken a decision,
Yes.
and it appears that they have been wronged because of some decision or lack of action. For some others, they have been made to suffer. Everyone aspires to go to a higher post. After all, promotion is a fair consideration for promotion is a basic right. You may not be promoted.
Yes.
That's a different matter. But
That's
a
a
fair
different-
consideration. They
Yes.
were fairly considered promoted.
Yes.
Now, because of some cabinet approval for other posts,
Yes.
they were connected, so they are still in the figure.
Yes.
In the meantime, unfortunately, they have retired.
Yes. Yes.
So
No.
under those circumstances, how do you redress as a welfare state? How do you redress their grievance?
The lordship, that is why on the previous occasion also,
Yes.
this is what I have submitted.
Yes.
Since after the DPC took such a decision,
Yes.
we have sent a letter again to the
When was
government
the
to take a
letter sent?
decision.
When was the letter issued?
7th of March 2024.
What is the response?
Your lordship, till date, I have not received any instruction. However, your lordship, since this is pending disposal before the government, why not, your lordship, dispose of the matter by directing the government to take a call on this letter?
Yes, what do you say?
Lordship, what I was informed by the parties. The government, they were waiting for the disposal of this petition. I'm saying that there is no interim, nothing. Department, government can just go ahead,
Correct.
whatever they wanted to do. Lordship, now, the reason is, now they are saying that taking back or postponing our promotion to 2022. now. The reasons why 2020 cannot be given to us, that is one reason. And that is how I'm going to place some authorities there. Every year
No,
promotions were
what
given.
we are thinking,
Yes, Lord.
to balance the equities, just a proposal from the court. We can keep this pending. We make it clear that pendency of this shall not be a bar for consideration and finalization 2022, but that will not affect your rights and interests which you have raised in your petition. It will still be open for you to make your submission or make out a case for giving effect, at least for motional basis, from the date when you are initially promoted.
Motion promotion to Lordship.
No,
From the date.
from 9/6/2020, which was the initial date of your promotion.
Yes.
Since you have not worked
Yes.
in the higher post, the principles of no work, no pay will come.
Yes.
But that will not be the end of the matter. You will be still entitled to a fitment, higher scale of pay,
True.
and consequently a higher pension rate.
Lordship.
From 2020, 2 years will make a lot of difference. If let them make it from 2022, if you may take a call whether you proceed with the repetition, and you may be satisfied after so much.
Yes.
And if you think that no, you should agitate your right, that it should be given effect from 2020, we can adjudicate. First, they have come forward with a proposal,
Correct.
which is towards some kind of a redressal of your grievance. Let them ameliorate your problem to the extent possible, then we'll decide.
Lordship,
We'll not,
if I may be allowed.
we are not expressing anything on merits. So far as your claims are concerned, as well as his defense, we are not saying anything, either taking your side, not his side.
Lordship, so my submission is, whatever it may be, because even personally, I had been to the department just because considering the
Now,
sufferings of the petitioners.
we'll say something more. We'll say that not only pendency, we'll direct the government to finalize within 45 days.
Your Lordship, the model code of conduct.
No,
No, Lordship, one thing, one
that
thing,
is-
Lordship,
Lordship,
one thing.
make some more time, don't worry.
Yes.
Lordship, one thing, let me make a submission. Since 2020, my the promotion order, 9/6/2020, that promotion order is not cancelled or not revoked by the recalled by the authority till today. That's still stand. That's still stand.
No, that was kept on hold.
Kept on hold, just simply kept on hold.
Kept on hold.
Lordship,
That
was
it has not been given effect to.
Yes.
Yes,
You may be correct in contemplating that unless those are cancelled,
yes,
a valid order, it still remains.
Yes,
Now the
Lord.
question is from what date it should be given effect to?
Lordship.
Should be from 9/6 or from 2022 or that is it. Please wait.
Lordship, one thing, my apprehension, because from before, they were saying that taking back my promotion to again 2022, for which I'm before this court. Lordship.
Yes.
Yes, because of that, I'm before this court. One thing to be considered, Lordship, my same batch, 1988, those who have appointed and similarly situated person, now they have got double promotion and retired. They have even got the special grade and retired now. The reasons why I cannot be given 2020, this is my case, Lordship. This is my case, Lordship.
Those persons who were appointed in 1988 along with you, they must have been seniors to you.
They are very much, yes, yes.
Your
But
Lordship,
see, every year,
whatever
since
it is,
as I have submitted, since 2006, 2007, whenever vacancy arose, promotions were considered until 2016, when my names comes to number 1, that I have filed, Lordship. So then from there, there has been my promotion has been stopped. Only in 2020, after a gap of 2 years, I happily accepted, but that too was again put on hold. And now they are postponing my promotion.
So tell us one thing, the post of special grade, is it required to be filled up every time with a cabinet approval?
No. And for the first time, as DPC is seeking for the promotion to the post of supervisor, they will admit. This is for the first time, Lordship.
No, why we are asking
Yes.
is you have been harping that every year there have been promotions.
Yes, Lordship.
Now, the policy of promotion has started in the year 2003.
2003.
There are
Yes,
three
after
different
adoption of policy.
yes. Now, from 2003, there has been obviously there has to be promotions from your grade, from the post of
Special grade to supervisor.
grade 1 to supervisor, then
Yes.
supervisor to the special grade.
No, special grade is for the first time. That has been proposed. There is no cabinet decision.
Special grade was,
And
the
for
post
that
was
reason
created
why-
only on 13,
For that
13/6/2022.
reason,
Your
my case
Lordship.
has been
This
put
is
on
why,
hold.
this is why.
And they have
This is why.
even availed this further promotion. Now I'm not giving even 2020. Is it not discrimination?
Your Lordship, as your
No, no,
Lordship is well aware,
When was special grade created?
13/6/2022.
2020.
And this is the date exactly where we are
From there, I'm
contemplating
my
to
promotion
promote
is
the
fine.
petitioners as well from this date. This was the date where the
Nothing
post
to
was
do with my
created.
case, with my case. If I'm to be given that benefit, Lordship, I will be affected from there. But that is nothing to do with me in my case. My immediate senior, the one who is just above me, he got double promotion and retired. Now I'm not giving even 2020. What is the reason? It's not that discrimination has been made to me, Lordship. Just because of that, only I'm before this court and to dispose of the matter on merit. Since 2020, these have been keep dragging. Several meeting has been conducted. Finally, I had no other option, so I had to send some of the advocates even there in the meeting. Finally, no concrete outcome for which that representation was submitted. It was just thrown out from the table. So with no other option, finally I came before this court. That is all, Lordship. I'm showing that, okay, why that's 2006, 7, 8 promotions were given and see why 2020 is also not in the positions to be considered. So if to postpone any promotion,
Your Lordship,
has to be reasonable ground, has to be.
The Lordship,
Sure.
if I may be allowed to make one suggestion, let the government take a decision. And whatever, if the decision, the petitioners is
since
aggrieved by that
2020,
decision,
Lordship.
Your Lordship, then
I have been
they have
waiting.
every liberty to come and approach this court again, challenging those decisions of the government. Otherwise, Your Lordship is well aware that
Pensioners
the
cannot
promotions,
just keep waiting. They are their employees, Lordship, just to see the welfare.
Your Lordship,
And the promotion is not the charity, it's Lordship.
promotion cannot be
Lordship,
cast
you are
from
well
the
aware.
date the vacancy arose. Your Lordship is well aware of that.
Explanation has been made to the.
Is well aware of that, Your Lordship. There's a ruling on it, Your Lordship is well aware.
But as of 9/6/2020, when you had actually promoted these petitioners
Yes,
to supervisors,
yes, my lord.
there were clear vacancies.
This
It is
vac-
not a question of that vacancy is there.
I'm going to
So
show
I
the
should be
release
given the
order for- I have
benefit
got the
of
release
promotion.
order.
You had given them a promotion.
Lordship, but that is not the issue here. The issue is that vacancy was the promotion was given because of the vacancy caused by the promotions of the senior.
How
But
will
this
the
is what
petitioners
the
know?
petitioners has also mentioned in the writ petition.
Finally, I could able to obtain some documents and to show it to the court. Otherwise, all these
Okay.
were kept.
We dispose this of.
Your Lordship, then in that case, if the matter has been disposed of, kindly allow me to place some citations because I thought that.
Please, please.
Yes. Lordship, let my learned friend.
Yes, yes.
Yeah.
Which one are you citing?
I have 7 authorities, Lordship.
Yes.
I've made a list. Lordship, the first one. Quickly, let me just go to the below portion of the Lordship.
Yes.
Yes. Lordship, the first one is 2004, 12 SCC 540. In the case of state of Haryana and others. This is in respect of the policy, Lordship. Because government has adopted a policy. Lordship, paragraph 8. I'm just reading paragraph 8. That brings us to the challenge against the decisions of the High Court. It has been submitted that the standing order 28 and paragraph so and so do not create any right in favor of any person to get back possessions of the land. There has been no dispute with that proposition. However, at the same time, it is clear that the government, having taken a policy decision, must implement that policy decision fairly and uniformly. It is not open to the government to discriminate between persons similarly situated. This is one in respect of the policy, Lordship. Number one. Now, Lordship, in 2000, number 2, 2004, 1 TLR 263. In the case of Popsi, Onar and others, Lordship, versus state of Arunachal. Lordship, relevant portion is in paragraph 5. Paragraph 5. Whether this report can interfere. Paragraph 5, Lordship.
Yes.
It needs to be borne in mind that promotion is not a matter of charity, but a well-deserved right of a worthy employee, which the employee earns by putting in requisite standards of service for a specific period. Though the employer is not bound to fill up every vacant promotional post, yet continued denial to fill up such posts without any justified or justifiable reasons may be regarded as unjust and required intervention by a record. Lordship, then coming to the after 5 line, leaving after 5 line, excluding a particular lordship, after leaving 5 line, yes, excluding a particular class of employees from enjoying the benefits of promotion must be held in the absence of any reasonable ground as discriminatory affecting Article 14 and 16 of the Constitution. In HP State Electricity Board versus KR Gauhati, reported in so and so, the apex court has clearly held that that non-consideration for promotion is an infringement of Article 16 of the Constitution. It is well settled that consideration for promotion can be postponed only on reasonable grounds. This is how I'm before this court. Then, Lordship, the next one, 1999, 7 SCC, 2009, Lordship. In the case of Ajit Singh and others, this is very popular, and Lordship, I have placed only relevant pages. Yes. Paragraph 22 only, paragraph 22 and 27. Lordship, paragraph 22, it talks about the violations of 14 and Article 16, Lordship. Marriage. Article 16 and Article 14 and Article 16(1) are closely connected. They deals with individual rights of the person. Article 14 demands that the state shall not deny to any person equality before the law or the equal protections of the law. Article 16(1) issues a positive command that there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. It has been held repeatedly by this court that Clause 1 of Article 16 is a facet of Article 14 and that it takes its roots from Article 14. The said clause particularizes the generality in Article 14 and identifies in a constitutional sense equality of opportunity in matters of employment and appointment to any office under the state. The word employment being wider, there is no dispute that it takes within its fold the aspect of promotion to post above the stage of initial level of recruitment. Article 16(1) provides to every employee otherwise eligible for promotion or who's come within the zone of consideration a fundamental right to be considered for promotion. Equal opportunity here means the right to be considered for promotion. If a person satisfies the eligibility and zone criteria, but is not considered for promotion, then there will be a clear infractions of his fundamental right to be considered for promotion, which is his personal right. So, Lordship, then again, 27. This is very short. I may be allowed to read again. In our opinion, the above view expressed in Ashok Kumar Gupta and followed in Jagdish Lal and other cases, if it is intended to lay down that the rights guaranteed to employees for being considered for promotion according to 11 rules of recruitment by promotion, that is, whether on the basis of seniority or merit, is only a statutory right and not a fundamental right, we cannot accept that proposition. We have already stated earlier that the right to equal opportunity in the matter of promotion in the sense of a right to be considered for promotion is indeed a fundamental right guaranteed under Article 16(1), and this has never been adopted in any other case before Ashok Kumar Gupta right from 1950. So, Lordship, that is one. And then next, 1991 submit to SCC 199. Lordship, paragraph 5 only. Paragraph 5. As to the merits of the matter, it is necessary to state that every civil servant has a right to have his case considered for promotion according to his turn. And it is a guarantee flowing from Article 14 and 16(1) of the Constitution. The considerations of promotion could be postponed only on reasonable ground. To avoid arbitrariness, it would be better to follow certain uniform principles. Lordship, I won't go any further. Then, Lordship, the next one, 2004 2 GLR. This is the coordinate bench. Lordship, paragraph 35. About DPC. 35. To be considered for promotion when a person becomes so eligible is his fundamental right, and denial of such a right, if discriminatory, cannot be permitted by a report. In the case of Delhi Jal Board, Mahinder Singh reported in 2007 SCC 2010. The apex court held the right to be considered by DPC is a fundamental guaranteed, Lordship. This is important. Now, under Article 16 of the Constitution of India, provided a person is eligible and is within the zone of consideration. In the case at hand, the state respondents have completely failed to show as to why promotion could not have been accorded to the writ petitioners when the writ petitioner had become eligible for promotion in the year 1995 to 1996, Lordship. Then the next one, Lordship, 2014, 5 GLT 39. The operative parties, Lordship, relying in paragraph 10, Lordship, 10. The Union of India versus Amjad Singh Chauhan and others reported in so-and-so. It has been held by the Supreme Court that it is an accepted legal position that the right of eligible employees to be considered for promotion is virtually a part of the fundamental right guaranteed under Article 16 of the Constitution of India. A guarantee of a fair consideration in matters of promotion under Article 16 virtually flows from the guarantee of equality under Article 14 of the Constitutions of India. Same principle. Then next, this is the last, and it's a similar case, and it's a covered case. The ratio can be applied in this case. 2014 3 SCC 670. Lordship, here, a little lengthy, so I don't need to go in details. But Lordship, let me read out certain portions here, starting from paragraph 27. It is not a matter of dispute that the appellant was promoted to the rank of substantive Major General with effect from 7/1/2004. It is also not a matter of dispute that the substantive vacancy in the rank of Lieutenant General against which the appellant was eligible for consideration because become available with effect from 1/1/2007. Even though the appellant had nearly 14 months of military service remaining at the aforesaid juncture, the procedure contemplated for making promotion to the rank of the Lieutenant General was initiated for the first time just 2 days before the date of retirement of the appellant on 27/2/2008. Although it is the contention of the learned senior counsel for the respondent that the delay in convening the selection board and conducting its proceeding was not deliberate or malified. Yet, there can be no doubt about the fact that the appellant was not responsible for such delay. I will not go in detail, but again, paragraph 28, relevant portion. The questions that arises for consideration is whether the non-considerations of the claim of the appellant would violate the fundamental right vested in him under Article 14 and 16 of the Constitutions of India. The answer of the aforesaid query would be in the affirmative, subject to the conditions that the respondents were desirous of filling the vacancy of Lieutenant General when it became available on 1/1/2007. The factual position depicted in the counter affidavit revealed that the respondent indeed were desirous of filling up of the said vacancy. In the above view of the matter, if the appellant was the senior most serving Major General eligible for consideration, which he undoubtedly was, he most definitely had the fundamental rights of being considered against the above vacancy and also the fundamental rights of being promoted if he was adjudged suitable, failing which he would be deprived of his fundamental rights of equality before the law and equal protections of the law extended by Article 14 and 16 of the Constitution. That Lordship, coming to the, instead of going in detail, coming to the last portion, whether he was entitled for the monetary benefits or the concession benefits. Lordship, I will straight away, leaving aside 33 and 34. Lordship, last. Insofar as the present controversy is concerned, there is no doubt whatsoever that a clear vacancy against the rank of Lieutenant General became available with effect from 1/1/2007. At that juncture, the appellant had 14 months of service remaining. It is not as if the vacancy came into existence after the appellant had reached the age of retirement or superannuation. The present case is therefore not covered by the technical plea canvassed at the hands of the learned senior counsel for the respondent. The denial of promotions to the appellant mainly for the reason that the appellant was on extension in service to our mind is unsustainable besides being arbitrary, especially in the light of the fact that the vacancy for which the appellant was clamoring consideration become available well before the date of his retirement on superannuation, which we have therefore no hesitation in rejecting the basis on which the claim of the appellant for the onwards promotion to the rank of Lieutenant General was declined by the appointment committee of the cabinet. In view of the fact that we have found the order of rejections of the appellant claims for promotion to the rank of Lieutenant General on the ground that he was on extended service to be invalid, we hereby set aside the operative part of the order of the appointment committee of the cabinet. It is also an appearance that the selection committee had recommended the promotions of the appellant on the basis of his records of service, past performance, qualities of leadership, as well as visions out of the panel of four names. In its deliberation, the appointments committee of the cabinet did not record any reasons to negate the aforesaid interference relating to the merit and suitables of the appellant. We therefore of the view that the appellants deserve promotion to the rank of Lieutenant General from the date due to him ordered accordingly. On account of his promotion to the post of Lieutenant General, the appellant would also be entitled to continuations in service till the age of retirement on superannuation stipulated for the Lieutenant General. That is still his having attained the age of 60 years. As such, the appellant shall be deemed to have been in service against the rank of Lieutenant General till 28/2/2009. Needless to mention that the appellant would be entitled to all monetary benefits which would have been due to him. So this is one case. Lordship, so these are the authorities in support of the case. My fundamental rights have been violated in this case. So this is my humble submissions to pass and set aside the letter and take effect of my promotion.
Now, please, ma'am. Your Lordship, I'll be relying on these two citations.
Just a minute, please.
Madam.
Yes.
Lordship. Lordship, the first citation is AIR 1990, Supreme Court 442. Lordship, I will read para 4.
Yes.
If I may be allowed to.
Please.
There is no statutory provisions that promotions to the post of Scientist B should take effect from 1st of July of the year in which the promotion is granted. It may be that, rightly or wrongly, for some reasons or other, the promotion was granted from 1st of July. But we do not find any justifying reasons for the direction given by the tribunal
that the promotions of the respondent to the post of scientist B should be with effect from the date of the creations of this promotional post. We do not know of any law or any rules under which a promotion is to be effective from the date of creations of the promotional post. After a post falls vacant for any reasons whatsoever, a promotion to that post should be from the date the promotion is granted and not from the date on which such post falls vacant. This is what I have been submitting, Your Lordship. The next
So
citation.
how does it help you? Is there a claim that posts are vacant, so you give me the benefit of promotion? Is it there a claim?
Yes.
No, that is not their claim. It is your order which you have passed.
Your Lordship,
Your order.
Your
Make a
Lordship,
promotion.
2020.
It's nothing to do with when the posts had fallen vacant.
Your Lordship, 2020. They are saying that from 2020, they should be promoted.
No, they were promoted already.
Lordship, which was subsequently put on hold
That is the challenge.
yes, which was
They're
subsequently
not
put on hold.
claiming more promotion from a date when, because vacancies have existed, give me promotion. Is it their case? No.
Lordship, this is the reason why in their annexures, they are bringing all those lists showing that vacancy arose on this year, on this year, on this year.
That is only to show that irrespective of the concurrence of the cabinet, there were vacancies where they could have been easily accommodated or could have been accommodated.
Lordship, is that the grievances in the writ petition? No. They have never raised the issue in this present writ petition, Your Lordship. In fact, they are seeking retrospective promotion. They are seeking retrospective promotion, Your Lordship.
See, there are certain decisions which they are not the domain. It's not within their powers from which vacancies they are adjusted. They are only happy with an order of promotion.
Yes.
You withheld that because of the higher promotion is not concurred by the cabinet.
Yes.
As a chain reaction, you have been giving promotion from every year.
Yes. Your Lordship, if
Now,
that is the case.
Where are the vacancies gone of those years?
Lordship, if at all that they have challenged that, we would have brought it before the court that, look, this is how the vacancy has been accommodated, or this is the vacancy that is left, that is still
No,
vacant.
that is one part you have to explain that irrespective of vacancies they were only considered on the upgraded vacancies, not on those existing vacancies.
I understand, Your Lordship, but however, that is not put to challenge in this writ petition.
That cannot be a ground of challenge. That is what has come to the court by way of additional documents.
The only issue, Your Lordship, they have raised before this court is whether they should be promoted with effect from 2020 or not. Or it should be from the date that the cabinet gave its approval. There is the only issue that they have raised, Your Lordship.
The next decision.
Your Lordship. 2022, 6 SSC 105, Your Lordship. Yes, 105. Paragraph 14, my lord. 14. If I may be allowed to read, my lord.
Please.
That the High Court also fell in error in taking note of the delay in considering the case of the respondent to the promotional post of JAG 1. No officer has a vested right to be promoted to a promotional post, which is restricted to that of considerations according to law. The law in this aspect is settled by this court in Ajay Kumar Shakla versus Arvind Rai. 41, Your Lordship. That this court time and again has laid emphasis on the right to be considered for promotion to be a fundamental right, was held by K. Ramakrishna, in which was reproduced below, Your Lordship. So promotion is considered for promotion is a fundamental right, Your Lordship.
Correct.
Then, Your Lordship, para 18. Para 18, man. 1-8, my lord. If I may be allowed to read.
Yes.
A mere existence of vacancy per se will not create a right in favor of an employee for retrospective promotions when the vacancies in the promotional post are specifically prescribed under the rules, which also mandate the clearance through a selection process. It is also to be borne in mind that when we deal with a case of promotion, there can never be a parity between two separate sets of rules. In other words, a right to promotion and the subsequent benefits and seniority would arise only with respect to the rules governing the said promotion and not a different set of rules which might apply to a promoted post facilitating further promotion, which is governed by a different set of rules. Then para 20, Your Lordship. Para 20.
Yes.
This court is in Union of India versus KK Vedera has clearly laid down that the promotion to the post should only be granted from the date of promotions.
KK
and-
Vadera, you have just referred.
Yes. So this particular matters also, this KK Vedera cases was taken into reference and took a decisions on this, Your Lordship. So my whole submission is that, Your Lordship, it should be from the date the promotion is given effect to, not from the date that the vacancy arose, Your Lordship.
Now, which date the promotions were given effect to?
Your Lordship, that is what we have said, that we are ready to give that promotion with effect from
That is also,
2022.
that is also not certain.
No, Your Lordship, for that, Your Lordship, the department is already working out. Letters are there. It is waiting approval.
Since 2050.
Now, Your Lordship, that is why I say, if
Now,
at all,
if approval is not given,
then Your Lordship, they have whatever right to come before this court, challenging that, Your Lordship.
Think about the employees, oh,
Your-
they
your-
are-
your- your Lordship,
it's a
that-
welfare state.
we don't want litigations in the court. Only because state of Nagaland has less litigations.
Very
More
unfortunate. to
litigation.
come
No,
to
we
this
don't
stage.
want litigation. Everything should be settled amongst yourselves. There should not be any grievance.
Correct,
Nobody
correct,
should-
correct,
That is
correct,
right.
man, correct. Your Lordship, in fact, we are also trying our best to help the petitioners out. It is not that we are not considering the promotion. The citation that they have placed is
Yes.
non-consideration of the promotion. We are not doing that. We are, just that the date is in dispute. And the number of years, of course, my lord.
Okay.
Lordship, one order, because this will also. Lordship, so far my promotion order is not cancelled or revoked by the. So Lordship, in the worst conditions, this, in the case of Krishna Devi Malchand Kamatia, reported in 2011, 3 SCC, 363, Lordship. Lordship, only relevant portion, because not, that order still stand. Coming to paragraph 14, Lordship.
1-4.
Oh, 1-4. Sri Ram Jatmalani, learned senior counsel appearing for the appellant, submitted that in the presence of the order of this court, dated so and so, the appellants have instituted a civil suit before the Bombay High Court, wherein notice had been issued to the respondent defendant, and which is still pending considerations, and all factuals and legal issues had been raised therein. The validity of the notification dated 18/2/2009 is also under challenge, wherein to the extent that the said notification is void ab initio for the reasons that the procedure prescribed in law has not been followed, more so, the notification does not disclose what are the statutory provisions which confer the power competence to issue the said notification. Now coming to paragraph 16. 16. It is a settled legal position that even if an order is void, it requires to be so declared by the competent forum, and it is not permissible for any person to ignore the same merely because in his opinion the order is void. In the case of so and so, so and so, so
Now,
and
why
so.
are you relying this? For what proposition?
Lordship, because see, they have issued order, our promotion order. That is not cancelled. They cannot simply ignore it unless that is officially cancelled. Lordship, coming to the paragraph 19, this episode. Paragraph 19, Lordship. Let me just conclude from there. Thus, from the above, it emerges that even if the order notification is voidable, the party aggrieved by the same cannot decide that the said order notification is not binding upon it. It has to approach the court for seeking such declaration. The order may be hypothetically a nullity, and even if its invalidity is challenged before the court in a given circumstances. The
I
court,
don't think this is of any relevance.
Lordship,
This is only a declaration from court that an order or action is void.
whereas notification also has been.
The notification has to be declared by the court.
Then Lordship here even included the executive administrative order that when we come by the distance.
No, the declaration has to be a court, a forum.
Anyway, Lordship, that is
Not
yes,
required.
the principle.
But your contention will definitely be considered that that order of promotion is yet to be cancelled by the competent authority. The validity is
give
not the
effect
question, is not the subject matter of calculation.
Yes, seeking a directions to give effect of the.
See with this. But we'll reserve the judgment. We'll try to incorporate it with. Today we'll not have to. The hearing is concluded. Judgment is reserved. Try to have this day after tomorrow.
Oblige.
Obliged.
For hearing item number 35. Item 35.
Please, Lordship. Lordship, the petitioner is praying for pension and pensioner benefits, retirement benefits. Lordship, in the previous occasion, I was directed to refer to Sanjita Roy,
Madam, when did you retire?
2014 December. Lordship.
38th, 31st of,
31st of December 2014.
not December, I think November.
Uh,
December.
11, yes.
11.
No, 12 December. Lordship.
December. What is the age you have declared in the affidavit?
Lordship, there's been a mistake, Lordship. It's actually 63, but we wrote 83.
83.
Lordship, that was by mistake, Lordship.
Have you rectified the mistake?
I believe not, Lordship.
Affidavit is a sacrosanct document. There can be a mistake, but it cannot be just erased and corrected.
Lordship,
We have noticed that you have put 83 years.
Lordship.
And you were released in the year 10 to 2015.
Lordship, by order dated 10 to 2015, but with effect.
And you came before this court when?
Lordship, my first petition was in 2017, Lordship.
What did you do? That was the representation.
Lordship, yes. There was a direction to dispose of the my representation, and after that, since there was no action, we filed another petition, Annexure 8, Lordship, which was withdrawn, and we filed this present petition.
And instructions, we have seen an instruction 4/3/2024 from government. That petitioner was not the senior most. That is your instruction, written instructions, part of the records. And you have this policy of 2004 of 50%.
Lordship.
It is not that you are totally out from the purpose of promotion or regularization. You 50% of available vacancies were meant for them every year, and you are not the senior most. So where is the?
Your Lordship, this seniority list, Lordship, I am at serial number 622, and seniority at list number 143.
Yes.
But Lordship, if we look at this list, it's only with regard to Jugalis,
Yes.
not whereas the department is supposed to maintain category-wise seniority list and not as per the designation of post, Lordship. So the seniority list is only on the basis of the designation. And he was appointed, Lordship, in 1984. Lordship, 1986, Lordship, I'm sorry. But he's in serial number 143, and many of his juniors are above him in the list, Lordship. And
But
Yes.
even then, Your Lordship, they cannot deny the fact that he's not the senior most, Your Lordship.
Lordship, if I may be allowed, Lordship, there's, in another case, in a similar matter, same department, we have filed an RTI, and on the basis of that, we have a list of persons who were regularized. And in that list, Lordship, I may be allowed to.
Yes, yes. But where are these judgments? On the last occasion, did you refer to two judgments of the writ appeal?
Lordship, Pradeep Chakraborty, Lordship.
What is this? Where is EMD? So definitely there has to be these two judgments. Do you have copies of WA 27 and there's an office note?
Your Lordship, that, I was
WA
asked-
27 and WA, what is the other one? And WA 29. What are these?
that, WPC.
Not PC. Writ appeals.
Oh, yes, Your Lordship.
27 and 29. Those are disposed of.
Yes,
And
Your
will have a relevance in this matter.
Yes, Your
Do you
Lordship.
have copies of those?
Yes, yes, Your Lordship, I
Please.
have. In fact, I'm relying on those, Your Lordship. And
Let
sir,
madam have a look.
Lordship.
Are you aware of this?
I'm aware of this, Lordship.
What are these cases?
Lordship, this case is deliberated only on the OM 2015, Lordship. But Lordship, I retired in 2014, before even this OM was effected. So, Lordship, this will not have any implication on me, Lordship. Moreover, Lordship, I may be allowed to submit one.
No, we'll hear you. Don't worry. Let us see what it is.
First of May, Your Lordship have passed the judgment, and it's similar to this matter, Your Lordship.
Do you have copy?
Yes, of the judgment, Your Lordship.
This is the BBC. One second. Yes. What about the division bench? In the case, this. In WA 27.
Lordship, this this judgment only deals with 2015 OM, Lordship. And then, whereas I retired in 2014, before this OM was even in place, Lordship. So if any OM is to be applied to me, it should be 2004, Lordship. However, Lordship,
What about the OM of 2004, 50%?
50% seniority, on seniority come merit basis.
Yes.
Lordship. This is Lordship. Lordship, you will find that OM in the government.
No, that is okay. Seniority wise, 50%
Yes,
of
Lordship.
existing vacancies in every year.
Yes, Lordship.
Okay.
Yes, Lordship, that OM is there, but Lordship, I want to also make a submission that those OMs only deal with persons who are in service, regularization for their service, Lordship. Whereas I have been superannuated after serving the department for 29 years, Lordship.
No, if you have not read, see,
Yes, sir.
your avenues for regularization is not totally shut. You are covered by a notification of 2004.
No,
15 is a different one, which is
No,
30 years. You do not fulfill 30 years, and you say that in 2014 there was no OM of 2015. It cannot be applied.
Hmm.
So your not fulfilling 30 years will not come into the way. So what
Yes.
has to be considered is as per the existing notification at the time of your retirement. You retired in the year 2014. What was the notification which was in vogue? It was the notification of 2004,
Okay.
which gives an avenue of promotion up till 50% of the vacancy, depending on your seniority. They have been making a categorical assertion that you are not the senior most.
Lordship.
Then how do you overcome that?
Lordship,
Have you cited anyone that they were junior to you and given the benefit of promotion?
Lordship, we have not made that submission, Lordship. However, I've submitted the list of persons who are regularized in the PhD department, Lordship.
Are they junior to you?
Yes, Lordship, they are very much junior to
In
me.
the same post?
Yes, Lordship, there are some in the same post, but they are all work charge employees, Lordship.
No, are they in the same category?
Yes, they are all work charge.
Junior to you?
Lordship.
That's it.
Your Lordship, that I have not received, but even then, Your Lordship, I was asked to submit a security list at the time when he was.
No, are these statements, madam, which you are now making, is it a part of the repetition?
No, Lordship.
Then how do they revert it?
Lordship, when we filed this petition, we weren't going on the basis of 2004 OM, Lordship. Lordship, if I may be allowed to refer to this.
Now,
judgment
these
that-
persons might have been completed 30 years. Maybe they are promoted under 2015.
Yes, Lordship, if
That
that
time
is,
the OM was not.
Lordship, if that is the basis for
No,
the
no, see,
regularization.
madam, you may have a case, but you have to give them a fair chance to
Lordship.
respond. A fair chance is a necessity.
Lordship.
Now, your entire case is that your promotion has to be considered as per 2004.
Lordship.
That is the only avenue, since you are on a workshop basis. Now you are only you are subsequently trying to improve your case by stating that person junior to you have been given promotion. When were they given promotion?
It's starting from 2016, Lordship.
That is after the, in terms of the 15 policy or 2004 policy? Tell us.
Lordship, I believe that would be in terms of 2015.
15 policy, the matter will be different. They are on a different footing altogether. They completed 30 years.
Lordship. Lordship, if that is the case, then that may not be gone into Lordship. But Lordship, I would like to take your Lordship to Annexion 9, Lordship.
Yes, please.
This is a judgment of this honorable court. Same facts and circumstances, Lordship. Here also the Lordship. Page 19.
19.
Annexion 9, Lordship. Lordship, here, same facts and circumstances, the petitioner has served for Lordship, I'm really sorry, but I think it's around 27 years, Lordship. And and he was not given retirement benefits. So here the state had taken the stand that he's not eligible under 2004 OM, Lordship. So Lordship, the relevant portion is at page 21, Lordship.
Page 21,
Page
yes.
21, Lordship.
Yes.
Lordship, in the second paragraph,
Yes.
in the middle, Lordship, in the
Yes.
case at hand,
Yes. Please
in
read.
the, Lordship, in the case at hand, an employee was taken in service way back in 1982. He was given promotion in 2 successive occasions. On the last occasion, on his promotion to grade 1 Chukidar, he was granted regular time scale. Although the word work charge has been prefixed to his designation, but yet he is granted regular time scale which militates such denunciation. Such a regular time scale is given to regular employee. His right to once a regular time scale is given to regular employee, his right to call the.
Madam, this, with all respect, this will not come into your aid because of the division bench.
Yes, Your Lordship.
Lordship, that division bench judgment only deals with 2015 OM, Lordship. Lordship, and
Lordship.
Yes.
Lordship, and in that regard also, I have a recent judgment of the division bench which have observed. Lordship, para 21, page 21, Lordship.
Yes.
Lordship, if I may be allowed to read the whole paragraph, Lordship, that in respect of the decision of the division bench of this court in writ appeal 27 of 2022, the learned counsel for the respondent submits that in view of the decision of the earlier division bench of this court in writ appeal 12, such and such, writ appeal 27 of 2022 is per interim in view of the law laid down by the Honorable Supreme Court. The submission so advanced by Mr. So and so received due consideration of this court and we find substance in the same. It appears that in the said two decisions, the division bench of this court, having considered the length of service so rendered by the petitioners of the said two petitions, had upheld the impugned decisions of the learned single judges by which the respondent authorities were directed to extend pensioning and other retirement benefits. Though the decision in KSH Ibobal Singh was discussed and distinguished in writ appeal 27 of 2022, the decisions in writ appeal 12 dated such and such having not been taken into account in the decision in writ appeal number 27 of 2022 and having been later in point of time, the decision in writ appeal number 27 of 2022 appears to be per interim in view of the decision of the Constitutional Bench of the Supreme Court in the case of Pranay Sethi Sutra.
What has been stated in laid down in Pranay Sethi?
Lordship,
In the case of the Supreme Court, Pranay Sethi, what has been laid down?
Lordship, I'm not aware of that case, Lordship.
You have to be aware because every time there's a reference to Pranay Sethi. What has been laid down in Pranay Sethi on the aspect of par inquiry?
Lordship, Pranay Sethi, I'm not aware. My apologies.
No, you should, before you rely upon, every time there is a reference to Pranay Sethi in the context of being par inquiry.
Lordship, there is also a book list that I would like to submit if your Lordship permits.
What is WA 12K of 2009? State of Nagaland case, do you have?
Lordship, Lordship, I have this book, please.
No, no, do you have the decision?
Yes, Lordship, it's in this book, please, Lordship.
No, the question is that, see, we are a single bench.
Lordship,
We have to follow the division bench. Then can one coordinate bench, division bench, held to be the decision of another coordinate division bench to be par inquiry?
Lordship,
Par inquiry can be held only by a larger bench.
Lordship,
If a division bench was not in agreement with another division bench, it's possible. Matter has to be referred to the Honorable Chief Justice for a consideration to create a larger bench.
Lordship. Lordship, however, that was the observation of the court, so I wanted to. place it
And
on record.
do you have chronicity? What has chronicity said?
Lordship, I do not have chronicity, Lordship.
You have to bring
But-
chronicity.
Lordship,
You have to read chronicity. You have to come prepared with chronicity. That's a case on MSCT. It's a very famous case. It has laid down what is a ratio decidendi, what is
Okay.
par inquirium, what is obiter, everything.
Mm.
You come prepared. When can you come? Thursday, is it possible Thursday?
Lordship, I believe the cases are fixed on Thursday, Lordship.
Then next Tuesday. But
Okay.
next Tuesday, this bench may not be there. But nonetheless, you try your luck. There is one judgment in your favor, one judgment in favor of the state.
Lordship,
Now, single judge is where to which direction to go. Which judgment will be more convincing?
Lordship, I have read Appeal 12 of 2014 also, Lordship, which,
That Singh case. 12 is
no, Lordship, it's a judgment of this division bench.
name.
State of Nagaland versus Kruvoto, Lordship.
That, okay, no, that was the only consideration in the later judgment, that 12 was not taken into consideration,
That's
isn't it?
apparently my case, Lordship.
Huh?
The one my learned from has just referred, that's my case. Because that goes back to 2004, OM,
Lordship,
interpreting the 2004 OM.
You are for whom?
I was for the petition in that case. So
No, here in this case,
I'm for the AG.
AG, okay.
In fact, here I have nothing to say, because my role comes only when they analyze the regularization.
No, the earlier judgment perhaps will not help her in terms of the later judgment of the division bench. But the division bench has again tried to differentiate in WA 35.
No, Lordship, what has happened is the 2004 was in place. It holds the field, 2004. Till 15, a new policy has been framed, but the 15 OM has not replaced 4 OM.
Correct. Both are
Both
concurrently.
are holding the ground. Now, what has happened is there are around 2-3 petitions filed challenging the 15 OM, because the contention of the petitioners in those cases is that 15 is unconstitutional. For the very fact that a person cannot be expected to serve for 30 years on scale and be regularized.
That validity has been under examination.
In the writ petition.
Which writ petition?
I don't have the writ petition number, but it's pending.
It's before DB.
No, single bench.
Lordship, one was listed today.
15,
also.
15 OM in a single bench.
Oh, that will not, that is not an act or rules. It's an OM. Okay.
Yes, sir. It's an OM. Because the government has not thought of making a legislation, but rather an executive instruction. Had it been a legislation, it would have been different.
Okay, then next Tuesday.
Lordship.
On request made by the learned counsel for the parties from a list on Tuesday next. You read Pranayacity because the later judgment has referred to Pranayacity more than once and said that it is par incuriam. Whether a coordinate bench can declare par incuriam.
Lordship.
Obliged.
Obliged.
You can take back this. Your- Did you supply this? 3527? Was it there? That's actually. This is remain here. And this one this is the computer code. I think this is code's copy. Madam, did you give to the raised?
27 W.
No, did you present before this code earlier also?
Yes, Your Lordship.
This was marked as code's copy. You make a photocopy and give it to the court. Okay?
Your Lordship, I can keep it then. I have extra.
Yeah,
copies.
that is it. It's code's copy. Cannot be coincide. Huh? And this one you have given. 35 of 2022.
Lordship.
Can you make a copy and give it to us?
Lordship.
For hearing item 36 and 37. Item number 36 and 37.
Your Lordship, here the petitioner's counsel has some personal difficulties. So Lordship, I pray that may come up after 2 weeks.
But there are sale deeds. How can it be donor?
Yes,
He had given the property for sale. Consideration, one is 18,000, one is 10,000.
correct, madam.
It cannot be a donor.
Lordship, I'm not aware of this. Lordship, I've only received
Day
instructions.
after tomorrow, we'll complete this. Day after tomorrow, there is nothing in this matters.
Yes, madam.
Uh, a prayer has been made on behalf of the learned counsel for the petitioner for accommodation for the parent. Considering the subject matter in dispute, from a list these matters for hearing on Thursday, day after tomorrow.
Lord.
Obliged.
Madam, I think this is also yours. At least
Yes, Lordship.